Yes, Mr. Goel.
My lord, as regard answer number 3, Your Lordship, I could not come to Shillong today. I want to do the matter physically. Can it be taken up after vacation, my lord, so that I can come and
Who's for the other side?
other side is here, Mr.
You've informed him?
Yes, yes, ma'am.
Okay,
They are
after.
inside Mr. Chetia.
Okay, yes. Yes. After vacation,
After
on the request of the learned counsel for the petitioner. Yes.
Deeply obliged.
Item number 1.
Wait, please, Lordship. Lord, before I resume my submissions, Lord, on 12th of August, my Lord, sir, pleased to issue an order.
On the
12th of August 25, there was a violation of the interim order in respect to which my Lord, sir, passed an order directing them to file a reply.
yes.
Why, during the substance of the interim order, they have collected the tax. Today, my Lord, it's been more than a month and they have not filed any reply.
No, but the thing is that as per the order 12.8, Mr. Ghosh,
Yes.
you were supposed to bring on record by affidavit. What is the
It was brought on record, my Lord.
by affidavit?
Yes.
When was the affidavit filed?
When was the affidavit filed? 13th.
Oh yes, that's the missed case number
That's right,
178.
my Lord. And my Lord, we are pleased to pass an order on 12th of August directing them to file a reply why they have deducted 3.28 crores during the subsistence of the.
Yes, sir.
As far as that amount is concerned, my lord, initially the recovery process was initiated by the center, my lord. However, my lord, enforcement agency, my lord, they are not made party in this case. They are the one who has done the deduction, my lord. That is electronic adjustment, my lord. That can be reverted back because it was not in their knowledge. So they have done the deduction. So it can be reverted.
So, Dr. Mojika, you can't.
That amount deduction amount was deducted.
No, we are not made. I have not sought instruction also on this matter.
Well, the position of the center is that they are not aware of this.
Yeah.
There's a letter that you have placed, so I can't blame the union for this. Union has said that go and tell the state, maybe they have done it. And state has confirmed that yes, we have done it.
My lord, for enforcement, there is different people, my lord, who are there. So that has been deducted, my lord. That can be reverted back anytime. If
So,
my
you
lord,
put an affidavit,
yes,
so we can dispose of the missed case also.
my lord, no.
Let it come and report.
My lord.
Let them take
Because you
necessary.
say that there's no willful violation that means.
My lord.
That's the only thing you should come and report.
They should reverse it.
We'll do it, my lord. I have instruction.
My lord, now.
So that's that.
Right.
Yes.
Yeah.
Now, my lord, today I wish to conclude my submission. I've taken enough time. On the last date, I was on this section 142 1B, the construction having been completed prior to GST.
Last was on 28th.
Last was on 28th. Yes, 28th of August.
That is time of supply.
That's the time of supply. Now, in that context, my lord also raised this point about Trump's custom duty levy. Goods are sitting in the warehouse, and my lord, so trying to reconcile between
No, I'm
140.
just giving an analogy, like time
That's
of
right. That's right. Now, I wanted
taxable
to
event.
correct,
like
correct,
you're saying. Yes.
correct. So I wanted to shed light on that particular thing to assist the court. Well, it takes the MADA judgment, Constitution Bench judgment of the Supreme Court, the recent 9 judges, just to get the conceptual clarity on this.
Today, 11 May.
This is the recent 9 judges Constitution Bench judgment in MADA. May I request my lord to come to para 182, which is internal page 113. The page number is at the bottom.
Yes.
Yes, my lord. Para 182. Conceptually, a tax has 4 elements. Nature of the tax, which prescribes the taxable event attracting the levy. So, taxable event. The person who is liable to pay, which is known as the taxable person. The rate at which the tax is to be paid, which is the rate of tax. And the measure or value to which the rate will be applied for computing the liability. So, these are the 4 pillars.
Yes.
Now, taxable event is the most crucial start point. Now, if my lord takes the constitution for a minute and schedule 7, entry 82 may be taken. List 1, entry 82.
How long will it take, Mr. Ghosh, today?
I should finish in an hour and a half. So, entry 82, my lord, sees list 1,
Yes.
7 schedule.
Yes.
It says
So taxes.
taxes on income. So, the taxable event is the income, and that circumscribes the legislative competence to enact the Income Tax Act. Similarly, entry 84, duties of excise on the following goods manufactured or produced. Entry 84, taxable event is manufacture. And there are other entries, taxable event is sale for a sales tax. So for GST, the taxable event is supply. Now, take a situation, my lord, that there is a manufacturing going on, and at every second there is a manufacture happening. The government cannot collect tax at that point in time. It is not administratively convenient. So they say, we will collect the tax, or you will deposit the tax when you remove it from your factory. So that is the time of removal. Those are extended period for collection of the tax or exaction. That has nothing to do with the taxability. That has already got frozen by having act of
So
manufacture.
removal will be from factory or from warehouse?
Correct. From warehouse, factory, as the case may be. So far as excise duty is concerned, the date of manufacture. So far as customs is concerned, date of import. So far as service tax is concerned, date of service. It is our respectful submission that so far as service tax was concerned, the taxable event was provision of service. Provision of service, because if I do not provide services, there was no competency to levy, and so on and so forth. But the point I pay the tax, whether at the time of raising of invoice, receipt of payment, those are all administrative convenience. That cannot be the basis to say that will define my taxability. Now, what has happened in this case? The respondents have concluded in their adjudication order that you are a construction service. We don't agree with that, but let us go with that it is a construction service. They have also concluded without any shadow of doubt, construction stood completed in 2014. And if that be the case, my respectful submission is taxable event having taken place in the pre-GST era, it falls within the ken of the service tax era. What may have happened under GST is the receipt of payment. But that is not the taxable event. Receipt of money is not the taxable event.
What he said is the delivery.
The delivery has also not happened.
That is what.
Because delivery is relevant for a sale of goods.
Okay, because your case is that we're not in construction. After we finish the entire project,
Right.
then we hand it over at
Right.
1 rupee.
Well, that is the correct. My lords are absolutely right.
Then?
That means that there was never in construction to begin with. I did it for myself. That goes to a different level. That's a different,
That's different level.
different
but
level.
How do you correlate that with the
Yes.
taxable events?
I'll tell
satisfy
that.
that.
Yes, I'll satisfy that. So, my lord had asked me this question: is it a ingenious argument I am making at the bar, or was it at the very outset? May I request my lord to take the show cause notice at 132
Of volume?
of the main petition.
(142).
Yes, page 132. Yes, this is where the show cause start, because that is the foundation.
Yeah, demand.
Yes, at page 138. Para 4.5.
1 second. Yes. From the same judgment, identifying land also.
Yes.
Yes. Will constitute. Yes. Page 130.
Page 138.
Yes.
Para 4.5 at the foot of the page. Third line from bottom. And maintain. My lord sees that?
Yes.
And maintain the project for the period of 20 years. As such, it appears that the concession agreement is in nature of a construction agreement for which annuity amount will be paid. And then hence, the authorized representative of JSCL in the statement have also deposed that the agreement in nature is purely nature of construction of road and maintenance of the same for concession period for which deferred payment will be paid. Hence, it emerges that JSCL has supplied the services of construction of road to NHI. This was the allegation. How did we meet that? If my lord comes to the rejoinder to the state, I had annexed my reply. Rejoinder to the state. Page 73. Starts at 50. 51 it starts, the reply.
359 pages. 1 second. That is at page?
Page 73, para 48.
Yes.
Para 48.
Page 72. It starts on 72 in our paper book.
Very well. Para, let me take para 48.
Yes.
I first say,
that's the allegation.
Yes, just below that, the bold. The impugned show cause notice seeks to distort the true nature of the concession agreement. This was my first plank, that this is not a construction contract. This is where I gave all the theory about I construct from myself, it is a transfer of immovable property at the end of the day, I do operation, various things. And this clause B goes on from page 72 till about it goes on significantly. Now, thereafter, I then say at clause D, which is at page 75, para 52-53, in between. In between 52-53.
Yes.
Having said that it is not a construction contract and all those details, I then say without prejudice, substantial.
You remember this argument. Yes.
So this is what I have. So from the very beginning.
So your stand that substantial part of the transaction cannot be within the GST.
Correct.
That's it.
That was an alternate argument without prejudice, given the fact that they have not understood what I do.
Yes.
And in that, if my lord comes to this 142.11b, I had made reference to at para 60.
Yes.
In fact, para 60, just before the italicized portion, last line, the noticee invites attention of section 142(11)(b of the CGST Act, which reads as follows: notwithstanding anything contained in section 13, no tax shall be payable on services under this act to the extent that tax was leviable on the said services under chapter 5 of the Finance Act. So therefore it is not a new argument, it was there from the very beginning. In fact, I remember because
but it was an alternate argument.
it is an alternate
It is not your main argument.
It's not my main argument.
Right.
It's my alternate argument, right, my lord? So therefore, my submission was, and I indicated Wazir Sultan various judgments. I will not. I've already argued that. My submission is their reliance on section 140 is out of place. In fact, for a minute, if my lord takes that section that they had alluded to,
So you say more than 90% of construction was under the Finance Act, and subsequent,
that's right,
whatever percentage, 10% or 7% is under GST regime.
Under GST. Because, and the reason why I'm saying that is, this is the conundrum.
But isn't that an appealable consideration?
It may be, but there are other things. I'll explain that. The reason why I say that is, they force a construction of this agreement. Instead of a concession, they say it's a construction contract. They do not agree with whatever I have to say, that construction is not the bone, there is various things, concession, etc., privilege, right, etc., etc. They say, okay, fine, if this is the case, assuming you're right, then tell me where is your jurisdiction to levy tax under the GST Act? You're not wielding power under the Finance Act. If you are wielding power under Finance Act, yes, maybe yes. Since you are wielding power under GST Act, you have no jurisdiction to deal with events, taxable events, which have taken part under the Finance Act. So the appealable aspect also do not come. Appeal can apply if it is within the ambit of the statute. So, 142 subclause 10. This is what they are seeking to rely upon to assume jurisdiction.
140.
Yes. 142 subclause 10.
Yes.
Save as otherwise provided in this chapter, goods or services are both supplied on or after the appointed date, in pursuance of a contract entered into prior to appointed date, shall be liable to tax under the provisions of this Act. It only says that if you have a contract that has been signed prior to GST, so long as you make a supply during GST, I'll have the jurisdiction. Now the word supply here is the supply de facto.
That's your argument.
That's the argument.
Okay.
It's supply de facto, as defined under section 7, which is the charging, section 9 and section 7, which are the charging section. And the reason I make this submission is, the constitutional validity of this provision will sustain only if events and acts that have taken place after the 101st Constitutional Amendment have come into being. Because power to levy GST under Article 246A came under the 101st Constitutional Amendment.
So you come again to your argument of 142(11)(b.
142(11)(b). Because this is the protection that the Parliament in its wisdom gave, saying that notwithstanding anything contained in section 12, which is the time of supply, etc., etc.
Section 13.
Yeah, no, 12 and 13, yeah, B. Notwithstanding anything contained in section 13, no tax shall be payable on services under this Act to the extent tax was leviable on the said services under Chapter 5 of the Finance Act. Now, was I leviable to tax under the Finance Act? That's a question that may come from my lord. And I wanted to show to my lord what was the situation under the service tax regime. My lord, I had given the service tax compilation, small compilation. Let be, if it is a problem, I don't want to waste the time of the court. You take the POTR. So I'll just explain a lot, since I don't want to waste the time of the court. Finance Act 66B used to say, which was a charging section, it said that the service tax shall be levied on service provided, but collected in a such manner as may be prescribed. So the taxable event was provision of services. Then they came out with the point of taxation rules, which is similar to the time of supply rules under GST. I wanted to point that out. But under the point of taxation rules, so far as services are concerned, your liability to deposit the tax arises when you have completed the project.
Yeah.
Lord, this is the point of taxation rules. In exercise of powers under section 67A and clause so and so, the central government hereby makes the following rules for the purpose of collection of service tax and determination of rate of service tax. This is the rule that they had come out. Now in that, kindly have page 2, section 2 subclause E or rule 2 subclause E.
Just 1 second, Mr. Ghosh. Yes, please continue.
Yes, please. Page 2, section 2 subclause E, which is at the foot of the page. Point of taxation is defined.
Yes.
Point of taxation means the point in time when a service shall be deemed to have been provided.
Yes. E.
E. And if my lord comes to rule 3, which is at page 4,
Yes.
for the purposes of this rules, unless otherwise provided, point of taxation shall be the time when the invoice for the services provided or to be provided is issued.
Just come again.
Yeah.
For the purpose of these two, unless point
Unless
of taxation,
otherwise provided.
Point of taxation.
Yes, which
So
is,
do we have the same description here? We don't have that.
there is nothing here under GST.
Right.
That is why I was showing the definition of point of taxation at page 2.
Just to draw an analogy.
Correct.
Yes. Okay.
Okay, so page 2 subclause E, section 2E, point of taxation under service tax means the point in time when the services shall be deemed to have been provided. There is no deeming provision under GST, unlike what service tax used to have, but service tax had this. So there is a deeming provision. Now, rule 3 says, how do you determine? For the purpose of these rules, unless otherwise provided, point of taxation shall be the time when the invoice for the service provided or to be provided is issued, provided that where the invoice is not issued within the time prescribed in Rule 4A of the service tax rules, the point of taxation shall be the date of completion of the provision of services. So by virtue of Rule 3, if I have completed my project in 2014, I will be deemed to have provided the services under the erstwhile era.
Yes.
And there are other rules, other ways of trying to find out. I will not trouble my lord with all of that. So therefore the short point I say is, under the Finance Act, point of taxation for construction of whatever I did, if I didn't raise invoice much later, etc., the day I concluded the project, construction, which is what the heart of the matter they say, which is the matter according to them. So if that be the case, the Finance Act and the rules issued under have been saved under section 174. My liability stood frozen under that law. If they want to proceed against me, they have all the powers under that statute. They can't jump from that statute to GST and assume jurisdiction by relying upon 142(10). That is the protection under 142(11)(b). The notwithstanding what time of supply under GST says, if you are liable under the previous act, then this act has no relevance.
Yeah.
Now, what is equally interesting is a judgment. Can you get Central Coalfield? Where is Central Coalfield? Huh? Beloved, kindly have page 560 of the writ petition. Yes, 560 is where. This is an example to establish the point of taxable event under GST.
Can you give the page number? Sorry.
Page 560 of volume 2. Volume 1. This is how it starts. 560. My page numbers will change. Just open this only. Oh my god, it's not even marked.
No, it's okay. You just tell me the para.
560.
560.
Tell me the para. Can you see it from
Not this one. What is the PDF page number? 194.
PDF 193.
High Court of Jharkhand.
Yes, ma'am.
The same.
No, it's some other matter, Lord. Yes. Yes. Yes, yes, yes. Lord, this was a case under GST. At the advent of GST, there was something called a coal compensation, coal cess, which was withdrawn. And a new compensation cess came to be introduced. Now, the taxable event was raising of coal. But the point in at time when you have to pay that cess was at the time when you removed it. Argument was made by the petitioner. Look, the day when I removed the coal, this levy was gone under the erstwhile regime because now GST came into being. Therefore, you cannot levy tax. The Jharkhand High Court relied upon Wazir Sultan, which was the judgment that I have relied upon, to say that no, the taxable event was under the earlier law. Date of removal has nothing to do with your exigibility. That was the case. When it comes to para 3, which is at page 561. The brief facts of the case as it appears from the writ petition is that petitioner is subsidiary of Coal India and is a category 1 mini ratna. In the instant writ petition, the petitioner has challenged an order dated 20 passed by the respondent. But the said order, respondent number 3 has confirmed a demand of clean energy cess amounting to so much under section 11A of the Central Excise Act, read with rule 65 of the clean energy cess along with interest under so and so. The case of the petitioner is that with the introduction of GST, the levy of clean energy cess was replaced by GST compensation cess under the Goods and Service Tax Compensation Act. Accordingly, petitioner has undisputedly paid the GST compensation cess on all claims made post 1/7/2017. Then counsel for the petitioner has assailed the impugned order on the following grounds. Cess is payable on removal. This is what the argument was. Since on the date of removal, the rate of clean energy was not prescribed, there was no requirement to pay the cess. The clean energy cess rule stands repealed, and in absence of any saving provision, the levy of clean energy cess is invalid. And then clause 4, petitioner is paying compensation cess on coal supplied post 1/7/2017. The levy of cess twice over on the same transaction is ex facie unsustainable, manifestly arbitrary. Then my lord may come to page 568, para 11. This is where the lordships had framed the issue. What has that? Having heard the learned counsel for the rival parties and after going through the documents annexed with the respective affidavits and the amendments made therein, following issues arise for consideration. Whether the revenue is entitled to levy cess under the Clean Energy Cess 2010, which has been repealed by GST compensation cess under the Goods and Service Tax Compensation Act 2017. If the revenue is entitled to levy cess under Clean Energy Cess, then as to whether in the facts and circumstances of this case, the revenue can take recourse of the first provided to section 11A of the Central Excise Act on grounds of fraud. Then my lord goes to para 13. Which is at page 569. Para 13. From the bare perusal of the aforesaid sections, it appears that section 83(3) of the chapter 7 of the Finance Act itself provides for levy, collection and rate of tax at 10th schedule. As per section 83, the levy of duty is on the production of coal. The taxable event is production of coal and is not its removal. Further, the Finance Act 2010 itself provides for collection and rates of tax. Rule 4 and 5 of cess rule specifies the procedure that the cess is payable by 5th of the second month. This rule does not specify that cess is to be paid at the rate applicable at the time of removal. Therefore, prima facie it appears that the respondent had the power to levy and collect its clean energy cess on the coal already produced and lying in stock. To substantiate the above view, few aspects is to be seen. Section 3 of the Central Excise Act stipulates about levy of duty. In other words, levy is created under Section 3 of the Central Excise Act and the collection of the same is regulated by the rules. The taxable event for central excise is manufacture or production of goods and not removal of goods. In other words, the moment the goods are manufactured, the levy becomes payable. Thus, in the case in hand, the coal produced on or before 1/7/2017 but cleared thereafter would be liable to tax. Then they rely upon Wazir Sultan, which is the judgment that I have also relied upon. May not recalls that. I'll skip all of this. Then relevant thereafter, just to mark it out, para 14 and para 15. I'll just read para 15 and para 16. I'll end it here. Para 15, Malords are there?
Yes.
It is reiterated that liability to pay cess only accrues at the time of production and its payment is scheduled when the coal is removed in view of Rule 4 and 6 of the rules. Since as per Section 83(3) of the Finance Act, levies on production of coal, Rule 4 and 6 deal only with the time and manner of payment, discharge of cess and not that rate. And para 16. Thus, we have the considered opinion that the revenue is right. Revenue is para 15, my lord.
No, 16, you think?
Para 15 is at page 575.
Well, our para is 572 anyway.
Yes, ma'am. I'm so sorry.
Yes.
It is reiterated that liability to pay cess accrues only at the time of production and its payment is scheduled when the coal is removed in view of Rule 4 and 6.
Strange thing in this judgment
Sorry, my lord.
is that there are two para 15
I
and there are
think
two
he's
para
reading it
16.
from the-
Oh, yes, my lord, are right. There are two para 15s. I'm so sorry. Yes.
Yes.
At 572, there is a para 15. And I think the stenographer probably did something here. The
No,
next
I mean,
page also,
yes,
yeah,
yes,
there is a para 15.
because they must have typed it over and over.
Yes. It is reiterated that liability to pay cess only accrues at the time of production and its payment is scheduled when the coal is removed in view of Rule 4 of the Central Rules, cess rules. Since as per 83(3) of the Finance Act, levies on production of coal, Rule 4 and 6 deals only with the time and manner of payment or discharge of cess and not the rate. In this regard, reference may be made to the so and so, so and so. Then para 16, thus we have the confirmed opinion, considered opinion that the revenue is right in demanding the tax on production which was lying in stock as on the date of amendment and repeal of the Clean Energy Cess for the sole reason that the taxable event was production and only the payment was deferred at the time of removal. My respectful submission is taxable event under Finance Act was rendition of service. By point of taxation rules, completion of project. Where do they assume jurisdiction under GST? That was the thing. But because this is only to deal with their submission or their finding, it is a construction. Well, that's at the lower level. I've said we are not construction, all of those is there. Therefore, my lord, I'll skip. This part is over.
Yes.
I'll now come to the other small issues and then go to alternate remedy, my lord.
Yes.
But this NCLT order. Now, I had submitted that under the resolution process up to 15/10/2018, I had a immunity. Up to 15/10/2018, I had an immunity. Immunity was granted at the behest of the central government. I'll explain why. ILF's group of companies across the nation was bleeding bad. It had tanked. Large.
I saw the proponent was ILFS, right?
Yes, yes.
This one, yes. Now they've gone to dissolution also. I mean, to resolution.
It went to resolution, and then the current petitioners have purchased it as part of the successful
What about
result.
the
Others have all,
segments?
they're all, various buyers have come into ping. Several buyers have come in. Well, there were several companies, category blue, category red, category green. So we were one of them, we purchased it. So the initiator of the insolvency resolution was the Ministry of Finance, Ministry of Economic Affairs. They raised a red flag to the cabinet that the country will have an economic shock if we don't do anything immediately. Therefore, they initiated a process to take over the management of ILFS group and all the subsidiaries, and they said the resolution process will have to happen. When the application was filed for granting immunity, as it happens, the NCLT had not granted the immunity. NCLT had not granted the immunity. Matter was taken to an NCLT, and an affidavit of the central government, this is very relevant, was that yes, we agree to the fact that they should be granted immunity. I just want to point out that NCLT and what transpires thereafter is therefore relevant. If my lord comes to my writ petition, page 518. Well, has that? Annexure 32. Yes.
This is order 5923.
Yes.
Yes.
Heard learned counsel for the appellant as well as the learned counsel appearing for the Union of India. May kindly note this. This appeal has been filed against order dated so-and-so passed by NCLT, Mumbai. An application was filed by the applicant where reliefs A to H were sought, which has been examined by the adjudicating authority in its order dated so-and-so, which reliefs are to be the following effect. Kindly come to the next page, clause D. At the foot of the page. Direct and declare and direct that upon payment or discharge of the revised offer amount in the manner contemplated under the agreed form revised SPA, the following of Jorbat Shillong Expressway Limited shall stand extinguished. All claims disclosed or undisclosed and whether existing at or relating to the period prior to October 15, 2018 of all the creditors including the central government, state government, statutory, local or regulatory authorities to whom such claim is to be owed under any law including any law, a claim arising out of regulatory enforcement action which pertains to a period prior to so-and-so, and all liabilities whether actual or contingent and whether existing or at or relating to a period prior to October 15, 2018, including such claims in respect of which arbitration proceedings have been initiated against Jorba, Shillong, etc., for dispensation of that. Now, para 3. The transaction has approval of Justice D.K. Jain, which is also recorded in the order. It is submitted that the adjudicating authority has para 3 page 521. Transaction has approval of Justice D.K. Jain, which is also recorded in the order. It is submitted that the adjudicating authority has approved the transaction. However, with regard to reliefs D to G, which is what I read out, the adjudicating authority observed that the parties are directed to approach the respective stakeholders for grant of other reliefs claimed in the application. Learned counsel for the applicant challenging the order contended the reliefs D to G are consequential to relief A to C and above reliefs are claimed due to the clean slate theory under the revised resolution framework. In the appeal, a reply has also been filed by Union of India whereat para 5 and 12 following has been stated. Now kindly see this. In this regard, the respondent submits that it supports the caption appeal and requests that this honourable tribunal to allow the caption appeal on the following facts, circumstances and grounds. It is submitted that once the Honourable Tribunal approved the resolution process, sale of JSEL being satisfied with the sale resolution process and revised offer, it ought to have granted reliefs which were in accordance with the resolution framework. Para 5. Learned counsel for the Union of India submits that for the reliefs D to G, Union of India has no grievance. It is submitted that it was already indicated in reply file before the adjudicating authority that the appropriate orders may be passed. In reply to which has been filed in this appeal, it is stated that reliefs D to G can be allowed. We are thus of the view that reliefs D to G being consequential to relief A to C, the applicant was entitled to have been allowed when transaction with regard to A to C have been approved. We thus partly modify the order of adjudicating authority and allow reliefs under D to G. So immunity was granted by NCLT and it was supported by Union of India. Now if that be the case, yes, the central GST appropriate body is the Union of India. They were in the know of things. So whatever the rate of tax is 18%, assuming 9% goes to the union, they cannot now say that no, I will not follow that order. And the reason for that is, under the IBC Act, section 238, if my lord has the IBC Act, 238, I'll read out, I don't want to trouble. 238 says,
yes,
provisions of this code to override other laws. The provisions of this
is a totally or a different field altogether the arguing.
Absolutely.
With regard to what do you call it, like a sort of waterfall.
With regard to the assumption of jurisdiction to levy tax for transaction up to 1/10/2018. That was my point. It's in the pecking order. It's the lowest. That's why I'm taking it at the end. But that is only to show that 238 says the provisions of this code shall have effect notwithstanding anything inconsistent therewith contained in any other law for the time in force or any instrument having effect by virtue of any such law. So it has an overriding effect. Now, what the state alluded to, the state in their compilation, if Mala takes page 124 of the state's compilation, they made a reference to an electro-steel judgment of the Jharkhand High Court, where their lordship said that the state was not involved in the process. Page 124, the state's compilation.
One 24.
Yes.
Yes.
This is the judgment that was relied upon by the state, and para 28 was pointed out at page 134. Page 134, para 28. This is what my learned friend had read out. Thus, a conjoined reading of section 13(1)(b) of the IBA code and the regulation.
The last 3 lines of this paragraph 28 you read.
Yes, cannot be said to be binding on the state government.
Process and revision plan can be said to be binding on the state government.
Correct, because they were not involved. With greatest respect, this judgment has been quashed by the Supreme Court. This judgment has been quashed by the Supreme Court. That
By
my
which
learned
judgment?
field. Sorry.
By which one?
Yes,
By which judgment?
by in Ghanshyam Mishra Melot. Now kindly see Ghanshyam Mishra, which Melot will find in volume 3, page 181, volume 3. Sorry, 110. Why does it say 156? It starts at 110, is it?
Starts at 110 volume.
110, okay.
You're reading this, you're not opening the compilation.
Volume 3, no?
Volume 3 of the compilation.
There are 182. 181. No, where is it? 181.
Incidence of tax.
182 para is fine.
Page 181. Kindly now page 181.
Judgment starts at 110.
Judgment starts at 110. Ghanshyam Mishra.
181.
This part of the Ghanshyam Mishra.
This Jharkhand judgment was which year?
The Jharkhand judgment was 2020.
22.
Yes.
Yes, page 181.
My lord, between para 148 and 149, my lord will see
Yes.
civil appeal arising out of SLP civil number 7147 to 50 of 2020. May I read this? For the reasons stated, interlocutory applications for intervention on behalf of applicant Tata Steel BSL Limited is allowed. In the present case, the appellant challenges the judgment on order of base passed by the division bench of Jharkhand High Court dated 1/5/2020. Footnote 515 may be seen. Electro steel. Let's see that. Footnote 15.
Let's see, yes. Let's still.
Yes. By which the petition is filed by the appellant challenging the action of the responding authorities, thereby seeking to recover the Jharkhand value-added tax for the period between 2011, 2012 and 12-13 have been rejected. Both the learned judges have written separate judgments. Now, paragraph 152. Insofar as the judgment authored by Deepak Roshan J is concerned, the learned judge has observed that since the resolution plan was approved by NCLT on so-and-so, the 2019 amendment to section so-and-so IBC would not apply to the state plan. We find that the finding of the High Court that the dues owed to the state government and central government would not come in within the meaning of operational debt is incorrect in law in the light of the view that is taken by us. So also the finding that since the order of NCLT is prior to the date on which section so and so was amended, the provision of section 31 would not be applicable. Then kindly come to 154. Sri so and so learned senior counsel strenuously argued that RPCOC had acted in fraudulent manner. It is submitted that though the notice inviting claim was required to be published in local newspapers where the registered office of the correspondence debtor was situated, the notice was published in newspapers in Kolkata edition. As per regulation 6(2)(b) of the 2016 regulation, the said notice is required to be published in one English and one regional language newspaper with wide circulation at the location of the registered office and corporate office of the corporate debtor. I'll skip all of this. Para 156. Sorry, I think the next line is very important. Was published in Business Standard Anand Bazar Patrika of Calcutta edition, which have wide circulation Ranchi. The corporate office of the corporate debtor is at Calcutta, whereas his registered office is at Ranchi. In any case, it is to be noticed that the Forest Department of State Government had filed intervention application before NCLT as well as NCLT. When one wing of the state government has approached NCLT, I say Union of India, and NCLT, it is difficult to believe that the other organ of the state was not aware of the said proceedings. The contention of Sri so and so learned counsel that finding with respect to non-compliance of section 13 is not challenged by Electricity Limited is also incorrect in as much Electricity Limited has raised the specific ground in so and so. In the result, the appeals deserve to be allowed. It is ordered accordingly. The impugned judgment and order of Jharkhand High Court dated so and so is quashed and set aside. Now, apart from the fact that Electricity Jharkhand High Court is no longer law, now we are not even talking about good law, bad law, it's no longer law. Even reference to that section that my learned friend alluded to, which is section 31(3), that he should be informed, that also should not cut ties, because the other wing of the government was aware. Union of India, they were party. And the public announcement, if my lord takes, where is the public announcement? Volume 8. Which page?
It was made wide publicity.
Yes, I'll show that. Page 240 it starts.
And the relevant is at PDF page 251, 252.
252 में यहाँ से चालू होता है, right? 252, yes.
252.
252.
Page. You are looking at 250, 251, 252. Yes.
The Lord has 252.
Yes.
That's a PDF page. I don't know what's the page number.
252.
Yes, my lord.
249.
249.
Because if you see, so then it's here. It's not.
Where is it here?
एक second. You are at 260. Here, if you see, it's 249.
Yes, 249, right? But let me see 249. It's I think the printing, the page number has got merged with the black body. Lord is able to see 249 somewhere.
Not really.
Okay.
You want to? Lord, may I pass on my iPad?
Public announcement.
Yes. And there's a series of things, and Jurba Silong is listed there. That's what I wanted to show.
Where?
Yes, my lord. That is, the page number is a bit awry.
243.
Huh?
Can see.
My lord can see 243.
Yeah, 243. You can see that at the 43 is not here.
Yes, my lord. I'll take my lord through that. So 243.
Yes, only in the left hand corner where it says Jorabad Expressway.
Yes, it is there.
In this 243 left hand corner.
No, 243 in
Left
my.
hand corner, no.
243 left hand corner.
No.
Then so also in
So 243, my lord, is on the left hand side is Industry 6 shops. 243 on the left hand side is Industry 6 shops.
No, I'm looking at the public announcement of ILFS.
Yes, so public announcement of ILFS, the first page. Yes, in that, in the very first page, in the middle somewhere, my lord will see there is a column called name of company. So first column is name of company, date of incorporation, corporate, etc. address. Then there is another column, name of the company. My lord sees that?
Yeah.
13th entry.
It's getting a bit too confusing for us, Mr. Ghosh. I think we don't want to be mired in
I'm so sorry, but the
fine.
second
We'd like to
column.
read the fine print, but I don't think we can really.
You have a hard copy of this?
Yes, can you just help us from here?
Yes. Just point it out. Put the sticker.
Just mark it with a pencil.
Yes.
Yeah.
लीजिए जरा. कीजिए पेंसिल. ये पेंसिल लीजिए. जो बड़ा कर के कीजिए. टच से छोड़ दीजिए. ये दे दीजिए.
Yes. This is 44, 45, 46.
Now see the
page paginated. Yes.
Jorba Shillong Expressway Limited.
Right.
The date of incorporation was given, corporate identity was given, and the address was also given.
Yes.
So wide publicity was given. It is not that it happened under the cover of the night.
No, but why is it different from the other public announcements given in the other papers with regard to the other projects?
No, this is continues. There are other places. In fact, the very next page.
See, in this page 245.
Yes.
So it's name of the company did incorporation. So that is already given in the caption.
Correct.
Box. While in this, with regard to Joropa, it's given only in a like tabular form.
No, my lord, I'll explain. Because ILF's group of companies had about 200, 300 subsidiaries. Yes. So all the companies were listed. So there's one table on the left, name of the company with the details. Then there's another column, name of the continues, and that series goes on in the next page also.
To show that yes, there was adequate
publicity was given,
so that for creditors
right. So
to
therefore
come forward
can't,
and to
correct.
whatever
I mean,
make their claims.
Correct, and they were sleeping there today. They can more so when Union was the party, they supported us. So therefore that takes care of my NCLT point that my learned friend had raised. Now
2018, that means there can be no demand
for up to 2018.
Okay.
17 to 2018. I don't extend it thereafter. Now I will come to the alternate remedy part.
Yes, that is more important.
Now before I make my submission, some opening remarks on this, Milord. Milord knows, sitting in 226, that article itself does not make any prohibition. It does not say that if there is an alternate remedy, 226 cannot be invoked.
Yes.
It is therefore a self-imposed restraint that constitutional courts have imposed on them. And there are at least 5 exceptions. There could be more, but at least there are 5.
You've got a different compilation for this?
Yes.
How do we reconcile these compilations with the Ghosh?
I will make a full single compilation as I had promised, my lord. So there are 5 known but before my lord takes the compilation, I'll just explain what I'm saying. Yes. There are 5 well-known exceptions to alternate remedy. First, if there is a violation of natural justice, then alternate remedy does not come in the way. Second, if validity of an executive order or a legislative action is challenged by this. Third, if it is a jurisdictional issue, jurisdiction to initiate, jurisdiction to proceed, create evil and civil consequences. Fourth, if there is a pure question of law, where there is no disputed question of fact involved, it's a pure question of law. And fifth, if there is a patent illegality, perversity at the face of it. It's my respectful submission that all 5 exceptions apply in my case. Some aspects fall into some basket, some aspects fall into the other basket. So let me take one after the other. So for validity is concerned, there are 3 things I have challenged. The notification through which DGGI has been accorded vested with the power of an additional commissioner, etc. That 14 of 2017.
Proper officer.
Proper officer, that notification.
Yes.
This could not have been assailed before the appellate authority. B, the circular of the board through which instead of commissioner in the board, assignment has been done by the commissioner, assignment has been done by the board.
Yes, board.
Proper officer, that I have challenged.
Yes.
C, that circular of the board through which they have said that this kind of project is liable to GST and not exempt. That other circular, which fell out pursuant to the minutes of the GST Council, change of heart.
Entry under
Entry 23A, correct, correct. That interpretation. So these three are validity issues, and therefore that exception applies to me.
Yes.
B, on the jurisdiction aspect.
Okay.
If the authority who has issued show cause notice is bereft of power because of 14 of 2017 being bad in law, then the issuance of show cause notice was without jurisdiction. He was not a proper officer.
Yes.
If the authority who has adjudicated the particular order
Yes.
is not appropriate, is not proper,
Not competent.
not competent because of the because of the circular
Yes.
that I've challenged, then the adjudication is also without jurisdiction.
Yes.
Third, if what I have done is a transfer of an immovable property at the end of 20 years, and the definition of the word construction excludes those cases where payments are made after the certificate of completion is issued, as in my case, where definition of construction services I had shown earlier on, that if the payments are made after the completion certificate, then it's not a construction service. And what I've done is a sale of immovable property, land. I had shown the judgment of Anant Mills to say road therefore becomes part of the land above and below. Then the GST legislation does not bear any jurisdiction to levy tax on those. Because as a creature of statute, you have to operate within the scheme of the act, which says only supplies to be taxed. Anything that is a non-service, anything that is part of the Schedule 3, which is sale of immovable property, you have no jurisdiction to levy tax.
Yes.
The second jurisdictional issue I had raised, that assuming that I am wrong in all my submissions and the state or the respondents are correct, that it is a construction project, then the construction having been completed prior to GST, where is your jurisdiction under GST to attach tax on that?
Yes.
Third jurisdictional error I have pointed out, that section 74 is what you have invoked. It's a question of suppression. That is a jurisdictional fact. Absent those jurisdictional facts, you cannot assume jurisdiction under 74 and mulct me with a tax liability. And why did I say section 74 cannot be invoked? Because it's a pure case of change of heart. For 4 years, you led me to the garden path, said I am exempt. Suddenly there's a change of heart and you say no, circular comes out and you withdraw the notification thereafter. I can't be said to be suppressing. So whenever there is a section 74, element of suppression should be obviously stated in the facts itself. It cannot be a case of interpretative issue leading to a suppression. Because mere non-payment of tax is not suppression. Suppression has been interpreted by the Supreme Court to mean intentional defrauding of the revenue, knowing fully well the position. Deliberate omission not to declare things. Where is the deliberation? I had a GST Council minute in my favor. Then you withdrew the notification later on. You came with the circular. So section 74 also cannot be
Can be invoked.
Yes.
Okay.
Fourth jurisdictional point is, in any case, the NCLT order protects me to some extent. Because if I have been granted an immunity and section 238 IBC has an override over GST and every other legislation, it is not a case where in a collateral proceedings I'll have to enforce it. Every forum where they want to enforce it, I can place this order and seek my immunity. That is the purpose. Otherwise, the NCLT order becomes an empty formality. Because if for enforcement of NCLT, if I have to take proceedings out against the union or the state before some other forum, then the whole efficacy of NCLT order falls. That is why 238 is there, that if it is an immunity, all of you must respect it.
Overriding.
Overriding.
Okay.
So that is what the jurisdiction.
That is already argued.
Right. Now I come to the natural justice violation, my lord.
Yes.
My lord recalls that we had come before this honorable court at the show cause stage.
Yes.
2 submissions I had made. In fact, I was appearing before my lord at that time, 3 years back or 2 years back. We had an apprehension that this show cause notice is conclusive, and because they seek to rely upon the circular, no useful purpose would be served by relegating me to the alternate remedy authorities, because the view is known. It's an empty formality. I do not expect any fair trial from them because they've already made up their mind. My lords took a leap of faith on them, saying that no, don't worry. You put your submission, maybe they will react otherwise. Maybe you tell them the Karnataka High Court judgment, they'll react otherwise. In fact, Mr. Muzika was fair enough to say that what stops the authority from looking at Karnataka High Court judgment? They will probably. My lord recalls that.
Right, yes.
We bowed down to that. Supreme Court also said the same thing. Why do you fear? But what was a primal fear at that point in time has become a reality. And the adjudication order has gone exactly what we anticipated they will end up doing. In the sense, the conclusion in the show cause notice has become a confirmed demand in the order. Same line of...
Where is national justice violation come in? Then?
Yes, my lord. When show cause notices are premeditated, there is a violation of natural justice. I'll place the judgments.
You have judgments for that?
Yes, yes, yes. When show cause notices are premeditated, then it's a violation of natural justice. Second, when circulars are relied upon by the department to create a charge of tax, alternate remedy has been held to be not efficacious because the departmental authorities will always be bound by the circular, the chain of command.
Yeah.
So these 2 things therefore becomes relevant, and therefore what has really transpired today is an outcome of that bias, of that conclusive approach, of the fountainhead of the circular coming to me as a Damocles sword that you are liable to tax. And this is what it is. So now I'll show one by one. Let me start with that premeditated show cause notice, my lord. Lord, I may require...
But if,
yes.
remember correctly, they had touched upon a Karnataka High Court judgment, correct?
Yes, what...
But their interpretation only is different.
What they do is very interesting. Appeal is pending. Can that be a reason? They say we will not follow Karnataka High Court because appeal is pending before the DB. That can't be the reason, because Kusumi Ingot says the judgment on a central law is binding across. At best, propriety would have demanded, and I'm nobody to advise them. It was possible for the adjudicator authority to say that yes, you are exempt, and for the revenue to take it on appeal, saying that since appeal is pending there, we are appealing it. That would have been an appropriate course of action, a fair course of action. But to say that a High Court decision I will not follow because its appeal is pending is probably on the face of a 226 verdict. It flies on the face in that sense. And
okay. Yes.
So, my lord, I wanted to show kindly have page 137. I'm reading out from the show cause notice.
From the your
on my writ petition. Page 138. I'm sorry.
Yes.
Page 138. I wanted to show the conclusions in the show cause notice that was there from the very beginning. There, page 138. First line. As the agreement is for construction and maintenance of the road, JCL is not entitled to avail exemption under serial number 23 of the central tax, which pertains only to service by way of access to a road or bridge on payment of annuity. In a show cause notice, you have to put me to charge that please explain why are you eligible to exemption. They cannot say that you are not entitled. The view has been formed. Then kindly read next paragraph. 4.4. Lord, after alluding to the rate of tax, Lord has that, as per serial number so and so.
Yes.
Somewhere in the middle of the paragraph, my Lord will say, therefore the rate of tax.
Yes.
So after reading out the notification, he says, now concludes, therefore the rate of tax applicable on annuity amounts received as deferred payment for construction of road is 18% from so and so to so and so and 12% from so and so from so and so. The GST rate applicable for construction road and all government works is 18% as amended so and so. As per available records of statements subscribed during the period of so and so, it appears that JSCL is not paying GST on annuity received for the construction of road under so and so, under the assumption of that annuity payment is exempt. Article 3.1 of the annuity concession agreement 6.7 dated so and so specifies the details of grant of concession. As per agreement, the said article specifies the concession authority NHI and authorizes JSCL to construct, operate and maintain the project for a period of 20 years. As such, it appears that the concession agreement is not in the nature of construction agreement for which annuity amount will be paid. The authorized representative of GSCL in their statement have also deposed that the agreement with NHI is purely for construction and road and maintenance of, and the same were concession period for which deferred payment of annuity will be paid. Hence, it emerges that GSCL has supplied the service of construction of road of NHI and has not provided the service by way of access also. Who puts it in show cause notice? Hence, therefore you are liable.
Hence is a finding.
Yes, it's a finding.
Yes.
Then, when it comes to another paragraph, page 150.
Yes.
The CBIC circular becomes the fulcrum. Page 150.
Yes.
So, great length of discussion they have done on the CBIC circular in the show cause stage itself. That this circular says so and therefore we are liable to tax. And I don't need to take any further on this particular point and the law on this point. Now, may let me take my compilation. Page 10. Volume, this is volume 2. Page 10.
Page 10, the
of
one
volume
you gave
2
just now.
of the compilation, yes.
Oryx Fisheries.
Yes, sir. Now, kindly have para 14, para 22, page 13A, capital A. Para 22. May I read?
Yes.
For a proper appreciation of the points involved, the show cause notice is set out in extensio. Your attention is invited to our headquarter letter dated so-and-so and subsequent joint meeting with the buyer held at our head office so-and-so on the trade compliant receipt so-and-so. At the meeting, it was convincingly proved that the cargo shipped by you to the aforementioned buyer was defective and you have not so far settled the complaint. Therefore, in exercise of powers vested in wide office memorandum dated so-and-so, read with so-and-so, I hereby call upon you to show cause why the certificate of arts registration as an exporter granted to you should not be cancelled. So, the underlying portion is, at the meeting, it was convincingly proved that the cargo shipped by you was not compliant. Very similar to hence you are liable to tax, you are not entitled to exemption. Conclusions. Para 23.
Yes.
Relying on the underlined portion in the show cause notice, the learned counsel for the appellant urged that even at the stage of the show cause notice, the third respondent has completely made up its mind and reached a definitive conclusion about the alleged guilt of the appellant. This has rendered the subsequent proceedings an empty ritual and an idle formality. This court finds that there is a lot of substance. Para 23. This court finds a lot of substance in the aforesaid contention. It is well settled that a quasi-judicial authority, while acting in an exercise of its statutory power, must act fairly and must act with an open mind while initiating the show cause proceeding. A show cause proceeding is meant to give the person proceeded against a reasonable opportunity of making his objection against the proposed charges and indicated in the notice. Then the lordships go to explain what is the reasonable opportunity. I'll skip all of this. Kindly come to para 35.
Yes.
Going by the aforesaid test, any man of ordinary prudence would come to a conclusion that in the instant case the alleged guilt of appellant has been prejudged at the show cause itself, which was the fear that we had while we came before this court in the first round. Then when it comes to para 37. Therefore, the bias of the third respondent, which was latent in the show cause notice, became patent in the order of cancellation of the registration certificate. The cancellation order quotes the show cause notice and is a non-speaking one, is virtually an order in the eyes of no order in the eyes of law. Since the same order is an appealable one, it is incumbent on the third respondent to give adequate reasons. So therefore, the conclusion that comes out is Fair play has to be there from the very word go. And there they had failed to do that in that sense. That was the first thing, Lord. Then I want to take my Lord to page 18, Whirlpool, the linchpin judgment on exceptions to alternate remedy. Page. Oh shit. मेरे से कहाँ गया? ठीक है, ठीक है. Yes, my lord. Whirlpool, page 18. My lord has that?
Yes.
My lord, operative part is at page 25, para 15. My lord has that?
Yes.
Under 226 of the Constitution, the High Court, having regard to the facts of the case, has a discretion to entertain or not to entertain a writ petition. But the High Court has imposed upon itself certain restrictions, one of which is that if an effective and efficacious remedy is available, the High Court would not normally exercise its jurisdiction. But the alternate remedy has been consistently held by this court not to operate as a bar on at least three contingencies, namely, where the writ petition has been filed for enforcement of any fundamental right, or there has been a violation of principles of natural justice, or where the order of proceedings are wholly without jurisdiction, or the vice of the act is challenged. This is the universe that I mentioned. There are two other aspects which I'll come to a little later. Now kindly come to page 7. Page 7, this is Siemens Limited, my lord. Now the operative part, my lord, will find at para 9, which is page 8A. Those are there?
Yes.
Although ordinarily writ court may not exercise its discretionary jurisdiction in entering a writ petition questioning a show cause notice, unless the same entirely appears to have been without jurisdiction, as has been held by this court in decision of so and so, so and so, so and so. But the question herein has to be considered from a different angle, viz. When a notice is issued with premeditation,
Yes.
a writ petition would be maintainable. In such an event, even if the court directs the statutory authority to hear the matter afresh, ordinarily such hearing would not yield any fruitful purpose. K.I. Shepherd. It is evident in the instant case that the respondent has clearly made up its mind, etc., etc., which is exactly what has happened. What was latent has become patent in the adjudication order. Then, my lord, I take, my lord, to another judgment on what is called pure question of law. Lord, I wanted to take, my lord, to, in this compilation, kindly have page 54. Remember, has that?
Yes.
Union of India and others versus State of Haryana and others. Kindly have para 3 in the next page. Para 3. Having heard learned counsels for the parties at length, we are of the view that these are matters which should not have been dismissed by the respective high courts in suggesting an alternate remedy. The question raised was pristinely legal, which required determination as to whether provision of telephone connection and instruments amounted to sale, and if even so, why was the Union of India not exempt from payment of sales tax under respective statutes? The respondent counters such stance. We think that the question raised was fundamental character and need not have been put through a mill of statutory appeals in the hierarchy. For this reason alone, we set aside the respective impugned orders of the High Court to remit the matter back to the so-and-so. And the pristine question of law here is, does he have jurisdiction? Is it a construction contract as understood? Is it a case where transfer of property happens at the end of 20 years from the fact? There is no dispute question of fact. Do they have the jurisdiction? So these pristine questions of fact should be looked at by 226 jurisdiction, not by the appellate authority. This is the principle.
Questions of law, I mean.
Yes, question of law, pure question of law. Then kindly come to page 57. Aircel Limited versus Commercial Tax Officer. But has that?
Yes. Para?
Yes, but kindly para will be at page 63. In fact, kindly have page 62. At the foot of the page, the questions. In fact, interesting because Mr. Nariman, before he was elevated, he was arguing this matter. Page 62, at the foot of the page, there are two indents, my lord, 1 and 2, just before that. It is submitted, Mr. Nariman, that the issues that arise for a consideration are whether the transfer of one of the business claimed by the petitioner as the whole and that business qualifies for exemption under explanation 3 of section 241 of the Tamil Nadu Value-Added Tax. Whether the state of Tamil Nadu has no jurisdiction to levy VAT on telecommunication towers located outside the state of Tamil Nadu, as in the case of SLP petitioner in the case so and so. Whether the assessing authority has jurisdiction to pass an assessment order with regard to a composite transaction as in the nature of Aircel Limited, where part of the telecom towers are within the state of Tamil Nadu and part are situated outside the state of Tamil Nadu, etc. etc. Very similar construct as we have here. Mr. Bagadia, learned senior counsel for the respondent, would suggest that these questions can be gone into appeal. However, it is not disputed these questions are pure questions of law and could be gone into in a writ petition under the peculiar circumstances. In our considered opinion, the question that have been raised by the appellant being absolutely pure questions of law, the High Court could have decided these matters. We may hasten to clarify that as far as these issues are concerned and the facts brought on record which include documents are not disputed, we may say that facts are not disputed. It is meant that some transactions have taken place inside the state while the towers are located outside and the documents which are brought on record their existence not disputed. In view of the aforesaid, appeals are allowed and the orders passed by the High Court is set aside and the matters are remitted back to the High Court. The High Court is requested to dispose of this appeal within a period of 6 months. Again, reflection of pure question of law. Then when it comes to page 40, Godrej Sarali. Well, has that?
Yes.
Now, para 8 is at page 43. This is judgment of recent import. Para 7 and 8, page 43, my lord has. Not too long ago, this court in its decision report in commercial steel has reiterated the same principle in paragraph 11. That apart, we may also usefully refer to the decisions of this court reported in so-and-so state of UP versus Indian Hume and so-and-so Union of India versus state of Haryana. One of them I had pointed out. What appears on a plain reading of the former decision is that whether a certain items fall within an entry of sales tax statute raises a pure question of law. And if investigation into facts is unnecessary, the High Court could entertain a writ petition in its discretion even though the alternate remedy was not availed of and unless exercise of discretion is shown to be unreasonable or perverse. This court could not interfere. In the latter decision, this court found the issue raised by the appellant to be pristinely legal, requiring determination of the High Court without putting the appellant through a mill of statutory appeals. In the hierarchy, what follows from the said decision is that where the controversy is pure legal one and it does not involve disputed questions of fact but only questions of law, then it should be decided by the High Court instead of dismissing the petition on grounds of alternate remedy. Now, on the aspect of the circular vitiating the entire proceeding.
Yes.
I want to first show, in fact, my learned DSG made a statement 3-4 hearings back that these are all, this challenge to circular and notifications are an independent suit or independent cause of action, nothing to do with the order. With greatest respect, that is not the case. 14 of 2017 is the fountainhead through which DGGIB is the proper officer. This is deep umbilical cord. If 14 of 2017 notification was not there, he couldn't have become a proper officer. Same with the circular. The other circular, which is that board circular on construction liable to tax, etc. I want to first show, kindly have the writ petition to show the reference made by the to the circular in the adjudication order, to show that how deeply entrenched the circular was. May not take page 120.
But now you jump from natural justice back to jurisdiction.
Yes, my lord. Natural justice I have done. I am done.
You had already addressed jurisdiction earlier.
But this circular I had to deal with. Yes,
circular you already brought it up. Yes.
This circular to show that this was
it was reiteration of your
reiteration, correct. So at page 130, page 120, he starts his finding. Para 4.4.
Yes.
I have carefully gone through the records of the case, including the show cause notice, the above mentioned notification, circulars and written submissions, documents submitted by the noticee. The show cause states that GST on annuity payment is received by the noticee for road construction, falls under so-and-so and is liable to tax as clarified by the circular number so-and-so. So circular was predicated on the, show cause was predicated on the circular. Then his finding, when it comes to
4.7.
para 4.7,
7.
he talks about that SSC code, etc., etc. Then para 4.8.
Yes.
During 43rd GST Council meeting dated so-and-so, the issue was further discussed and it was clarified that 2023 of the notification number so-and-so dated so-and-so does not exempt annuity paid for construction roads. Subsequently, the board issued the circular number so-and-so. Relied upon that. Para 4.8, therefore, plain reading of 2023A makes it clear that it does not cover construction so-and-so, etc., etc.
So the lynch is that 7621.
Correct.
That they're deriving their authority from there, according to them.
Yes.
Yes.
So if this is a circular, then if it is predicated on that, then the alternate remedy, because what happens is, in fact, I wanted to take my lot through in this, my writ petition, kindly have page 595. Page 595, annexure 48.
Yes. Canon.
Today is 11th or 12th? 11th. In fact, I was just reading this judgment. Justice Sivaganam is part of the bench. Tomorrow is his retirement day. He is retiring tomorrow.
Justice?
Sivaganam, he is now the Chief Justice of Calcutta High Court.
Oh, yeah, cool. Okay.
He retires tomorrow. It was
Tomorrow?
Yes, 12th.
15th, right?
I was told it was 12th. Maybe 15th.
Very fine judge.
Very fine judgment. Very fine judge. Now, page 595, the judgment. Kindly come to page 597.
Yes.
Para 10.
Yes.
In response to a query raised by this court as to why the petitioner should not avail the statutory remedy as provided under the Act in terms of section so and so, the learned senior counsel submitted that once a clarification is issued by the Commissioner of Commercial Taxes, it will bind the subordinate assessing authority and it would be a futile exercise to go for an assessment. More so when the division bench of another high court on a similar provision held that these cartridges are accessories to printers and therefore the petitioner would be justified in approaching the court invoking jurisdiction under 226 of the Constitution. This was the submission. Now, my lord, kindly come to para 16. From the facts narrated above, it is seen that the Commissioner of Commercial Taxes has issued a series of clarifications, which is similar to our board, relating to the rate of tax for ink cartridges and toner cartridges based on the request made by manufacturers, successive dealers and manufacturers association for information technology, New Delhi. In the said clarification dated so and so, it has been stated that inkjet so and so are classifiable 12.5% at so and so. This was the clarification. Para 18. Thus, the department appears to have taken a firm stand wholly based on the circular clarification issued by the Commissioner of Commercial Taxes. In such circumstances, should the petitioner be relegated to avail the remedy under the Act.
Yes.
The Honorable Supreme Court in the case of Filter Co. considered the correctness of a decision of the High Court which dismissed the writ petition without entertaining into merits, stating that there is a remedy available under the relevant enactment, namely Madhya Pradesh General Sales Tax Act. Interfering with the decision of the High Court, the Honorable Supreme Court held that the High Court should have examined the matter on merits. As in the said case, there was an order passed by the Commissioner of Sales Tax which was clearly binding on the assessing authority, and by approaching the said authority, it would be an exercise in futility. Similar is the view taken by this court in the case of Bizarria Fast Food referred so and so. Several decisions to support such proposition were cited at the bar, which have been referenced at Supra, and it may not be necessary to refer to all this decision, and it would suffice to refer to the decision of the first bench of this court and so on. So I'll skip this part. As noticed of para 20, as noticed above, this court held that in view of the clarification issued by the Commissioner of Commercial Taxes, no fruitful purposes would be served by directing the appellant therein to go for assessment, and for that reason not to entertain the writ petition. It was further observed that tax matters where there is a division bench judgment of another high court on the similar matters provision, which are according to the division bench was a correct view, it is all the more reason for not to relegate the party to a procedure. So in the para 23, In light of the above decisions and taking note of the decision cited supra, in our view, circular issued by Commissioner, though stated to be without jurisdiction, which is exactly what I'm contending, the circular having been issued by the highest officer in the department, which is the board in my case, the assessing officers who are subordinate officers cannot be expected to take a different view, and therefore no useful or fruitful purpose would be served in directing the petitioner to avail the remedy under the Act, and therefore these writ petitions questioning the classification of goods are held to be maintainable for this court on account of reasons recorded above.
Yes.
Then, my lord, on section 74, I wanted to show that section 74 has been the fact whether or not the jurisdictional attribute of suppression is there or not. Absent satisfaction of that, they cannot assume jurisdiction. That was the point I was making. 2-3 judgments on this aspect, my lord. A Calcutta High Court decision which is at page 171 of this volume, volume 8, I'm so sorry, volume 8.
Volume 8.
Yeah.
Page
171. The judgment is Commissioner of Service Tax versus Naresh Kumar. Here Justice Sivaginam is the presiding judge. Not has that, page 171. Kindly have para 7.
Yes.
The respondent writ petitioner at the outset contended that the show cause notice is barred by time in view of 73(1) of the Act, and the extended period of limitation as provided for in the proviso to 73(1) could not have been invoked as the ingredients were wholly absent, which is what my submission is, that there cannot be any fraud suppression. Appellant Revenues raised a preliminary objection with regard to the maintainability of the writ petition, contending that question as whether the proviso 73(1) of the Act has been rightly or wrongly invoked involves factual determination, and therefore the writ petition should not be entertained. The learned writ court, after noting the decision of the Honorable Supreme Court in Whirlpool, opined that the court would not be justified in dismissing the writ petition at an initial stage without examining the contention raised in the writ petition, and that the show cause notice was without jurisdiction. Further, taking note of the decision of Honorable Supreme Court in State of Punjab by so and so, the court held that the question of limitation being a jurisdictional question, a writ petition challenging the validity of the notice on ground of the same being barred by limitation would be maintainable, notwithstanding an alternate statutory remedy. Further, the learned writ court referred to the decision of the Honorable Supreme Court in so and so versus D.K. Jadhav for the proposition that writ court would be entitled to examine whether the jurisdictional facts are correct or not. With the above reasoning, the court held the writ petition was maintainable. Having held so, the court then proceeded to examine the second contention raised by the writ petitioner that the show cause notice was barred by time and the ingredients required to fulfill for invoking the extended period of limitation being absent, the show cause notice is without jurisdiction. To examine the correctness of the contention, the learned writ court has noted the factual position which was occurred prior to the issuance of the imputed show cause notice dated so and so. The factual details, more particularly action taken by the respondent, by the department, and the response given by the assessee are illustrated below. Then kindly come to page 176, para 11. Sorry, 177, para 13. Lord, comes that?
Yes.
Yes. When the appeal was heard on 5th August 2022, we had framed 3 issues for consideration. Firstly, whether the writ petition was maintainable as against a show cause notice. Secondly, whether the extended period of limitation under 71 of the Finance Act as amended could have been invoked. And thirdly, what would be the relevant date for purpose of computation of period of invoking the extended period of limitation. On the first issue regarding the maintainability of the writ petition, we refer to the recent decision of the Honorable Supreme Court Radhakrishna Industry vs. State of Himachal Pradesh, wherein the Honorable Supreme Court has clearly enumerated the principle as to when a writ petition could be entertained despite availability of statutory remedy. The writ petition had challenged the show cause notice on the ground of lack of jurisdiction. The learned writ court was fully justified in examining such of those facts which were required to be decided as to whether the authority lacked jurisdiction in issuing the show cause notice. Therefore, we find that there is no error in the finding of the learned writ court that the writ petition was maintainable. In any event, the said issue has now become academic, as the writ petition which was filed in the year 2011 was allowed by an order dated so and so, against which present appeal has been filed in the year 2011. Then my lord comes to the next page. The second issue, para 14, as to whether the extended period of limitation could have been invoked. If the issue is answered in favor of the writ petitioner, there may not be a necessity to go into the third issue. As rightly pointed out by the learned writ court, the proviso to section 73(1) can be invoked only when there is an allegation of fraud, collusion, or willful misstatement, or suppression of fact, or contravention of provisions of the act or the rules with intent to evade payment of tax. Therefore, the show cause notice should clearly indicate the willful misstatement or suppression of fact or fraud, collusion, as done by the assessee with an intention to evade payment of tax. On a careful reading of the show cause notice, it is evident clear there is absolutely no whisper of any allegation of willful misstatement or suppression of fact and fraud, collusion as committed by the respondent assessee with an intention to evade payment of service tax. In the absence of factual finding, extended period could not have been invoked. Which goes to show that the writ courts go into the fact that whether the ingredients are present or not. Now, this aspect, there are other judgments, but I'll put it in my written submission. I don't want to. There are several judgments on this point. What transpires is the principle laid down by Supreme Court, Volume 6, page 52, Volume 6, Eastland. Push. 10 minutes. I conclude. I conclude it. Page 52.
Yes.
Para 31. And I'll only read this judgment, rest I'll put it in my written submission, because this gives the essence.
Yes.
It is settled law, para 31, it is settled law that for invoking the extended period of limitation, duty should not have been paid, short-lived or short-paid, or erroneously refunded because of either fraud, collusion, or misstatement, suppression of fact, or contravention of any provision of the rules. This court has held that these ingredients postulates a positive act, and therefore mere failure to pay duty or take out a license which is not due to any fraud, collusion, or willful misstatement, or suppression of fact, or contravention of any provision is not sufficient to attract the extended period. So, mere non-payment of tax is not a suppression. It should have a positive ingredient, mens rea, that I did it with an intent to defraud the revenue. And I therefore ask myself the question that for 4 years, not a whine or a whimper on my exemption. The GST Council initial meeting said yes, it has to be put at par with toll. Notification followed suit thereafter. And then there was a change of heart, much later, 2021. Under the circumstances, can I be said to be suppressed, and therefore how can there be a fraud? Therefore, that is what it is. In summary, therefore, my lord, I like take 10 minutes to summarize what I have just. If my lord takes volume 8, my lord has volume 8 right now, right? Kindly have page A.
This volume 8. Can I put it?
Page A.
Volume 6.
Sorry, then volume 8.
Yeah, volume 8. Yes. Page 6.
Page A.
E.
After the index, yes.
The grounds.
Yes. This is just the conspectus, my lord.
Yes.
What is it that I have therefore prayed before this honorable court? I have challenged the validity of circular so and so issued in contravention of notification 12 of 2017, read with notification number so and so, and contravention of second estimate. Issued in violation of section 11(3) of the CGST Act. In fact, I must pause here for a minute. I skipped this point. Section 11(3), my lord, recalls, says the central government who issues a notification can issue a clarification. That too, it has to happen within 1 year. Purport is that there should be no disruption that after 5 years you wake up and give a clarification. Otherwise, it's indirect taxes. Trade will go into a complete shock. So 1 year, that too clarification by the central government. We said this circular is violative of 11(3) because you did not have the power to clarify the scope of the notification. And that too you did after 4 years on both counts. The submission of the state was 11.3 is not relevant because central government has not exercised the power here.
Yes.
Such kind of submission, Willot, is nothing but a colorable exercise of argument.
Is there such thing as colorable exercise of arguments?
Yes, I would believe so.
The first time I've heard it in any argument.
Purely colorable.
I can colorable exercise of power, yes, but colorable exercise of argument, yes.
Because they realized that central government, if they had issued, would be in trouble. Now they colorable say that no, it's not the central government, I have issued it. There was no restraint on me. If the parliament has conferred power on the central government to issue notification and expressly conferred on the central government to clarify, you cannot arrogate yourself that power and say that I am not hit by 11.3. So therefore that was the point. Then C, being in the nature of administrative instruction, it cannot fasten tax liability, because that becomes an executive legislation and it goes against Article 265. 2, impugn minutes of 43rd GST meeting is arbitrary for the reasons that I have mentioned. 3, notification 14, read with corrigendum, vesting R4 with the power of proper officer is ultra-virus, section 3.
Important.
Yes, because the distinction between appointment and vesting has been wholly glossed over. No argument has been given on vesting other than to say the central government and the board is one and the same. That's the only argument, and I've given Supreme Court decision to say that look, your powers are de-alienated here. You are acting as a doing. Serial number 4, circular number so-and-so data so-and-so which assigns the power of proper officer on R5 is ultra-virus, section 291, because instead of commissioner in the board, it has happened by the board. So therefore to that. Then jurisdictional error, impugn orders and impugn show cause notice are without jurisdiction as R4 is not a proper officer, R5 is not a proper officer to adjudicate, jurisdictional fact under 74 for invoking extended period is not there, GST on work done prior to implementation of GST is not there, levy of GST on transactions which are immune to statutory dues and taxes claim NCLT, that's a jurisdictional fact. Jurisdiction of the state above, thus clause 6 I will restrain for a moment, I will not read it out right now. Then C, impugn order is fraught with perversity and suffers from patent illegality. This whole ex face patent illegality or error apparent on the face of the record is the manner in which they read the concession agreement as if it is a construction agreement. That's the perversity. That's the patent illegality.
Yes.
That is also one of the exceptions for a writ court to entertain a petition. So therefore this is what it was. Then there was a short written note I had given on one of the hearings, I don't know whether it is there, it's 3-4 pages, which was high level summary of nature of activity undertaken by the petitioner. 2-3 pages. Not the customs.
We are swamped, yes.
Yes, those 2-3 pages, my lords have got it.
Undefined syntax.
This highlight it.
Yes. Yes.
Yes.
Yes.
This note was to get to the state of affairs in terms of what I really do. This becomes the edifice. At para A, I have said what is the nature of contract I execute, that it is a concession fee, concession, privilege, meaning of word concession, all of those things I have explained. Then para B at next page. Per statutory framework, I don't provide construction services because the payment comes after the certificate of completion. So it is not a construction service as defined.
Yes.
Para C, the next page. I'm not doing works contract services either because the entire property gets transferred post 20 years. There is no transfer of property during execution of work. It's a transfer of an immune property. Para D, I claim immunity under the exclusion in Schedule 3, which is sale of land. And I quote judgment of Supreme Court in MADA Anand Mills, etc., to say what is above land, below land is land. So road is a land, therefore it's animal property. You have no power under.
That para 270, I remember.
Yes, correct, para 270. Then para E, I make a reference to the latest judgment of Supreme Court of July, where they said that you are discharging public function, and the public function as a concessionaire is to satiate the fundamental right of the citizen to have access to road. This is the root, this is the heart. And if that be the case, that anything that I do has to be necessarily an access to road. That is the root, because that is the fundamental of what I do, because I am exercising public function at the behest of the central government. And that be the case, entry 23 years straight away applies. Para F, operation of the highway is at the heart of the concession agreement, because nobody comes to me as a construction, because they could have gone for a construction model. There were 3 models: BOT toll, BOT annuity, BOT and construction. They never came to me for that. Because they wanted concession operation, therefore they came to BOT annuity. Para G, I have applied all of these points to the how the interpretation of the notification will have to be done in this context. Para G. Para H, I have said that there is no conceptual distinction between BOT toll and BOT annuity, except for the mode in which the money comes. The reason for that was the avowed purpose was to put toll and annuity at par. At the very fulcrum, that's the foundational. And I've also said that it is a misnomer that in toll, the right to collect toll is with the toll concessionaire. That's wrong in law. The correct position is central government levies the toll, and the toll concessionaire is only a custodian. He holds the money on behest, and then he is permitted to appropriate it for the services is done to NHI. This is the other aspect of the who am I, because this is where everything will boil down to. If there is anything that is not acceptable to this honorable court, the consequences could be fatal for me. I therefore respectfully submit, my lord. This impugned order is bad in law. The action of the DGGI as a proper officer is bad in law. The notification where vesting has happened is without authority of law. And everything else that has followed is also bad in law. I wanted to point out what is the frame of reference in the Customs Act. Because this issue of DRI, because service tax and excise had DGGI. In customs they have a DRI. There is some jurisprudence available on that under customs. And I wanted to point out how in the customs, they have done it so nicely, which they have failed to do. Now I kindly have volume 5 of my compilation. Because similar to GST, the Customs Act also says that the proper officer will be who is so assigned that function by the board. So if my lord takes page 1 of volume 5, notification number 40 of 2012, lord sees that?
Page 1?
Yes, page 1 of volume 5.
Volume 5. Now what is this compilation? Volume 5 is a thin one.
Yes, volume 5. Yeah, this should be notifications.
But it relates notification.
Yes, yes.
31/3/2022.
Yes.
Huh?
Yes.
No, it starts with 26 of 2022.
Not 12.
The very 40 of 2012.
So proceeded.
Huh?
No, you have also referred to this, no? 26 of 2022.
Yes, notification. Sorry, it is superseded by notification 26 of 2022. Yes, yes. Very page, first page, my lord. Notification customs superseded by notification number 26 of 2022. My lord sees that? The very first line. Yes. Just below that, Government of India, Ministry of Finance, Department of Revenue, notification number 40 of 2012. Now kindly see the language. Very beautifully put by the customs. In exercise of powers conferred by subsection 234, which is equal to our proper officer assignment under GST 294, of the Customs Act, the Central Board of Excise and Customs hereby assigns the officers and above the rank of officer mentioned in column 2 of the table below the functions as a proper officer in relation to various sections of Customs Act. Now kindly see who are these officers. It may not comes to page 3, serial number 4. The Deputy Director or Assistant Director in the Director General of Revenue Intelligence and Director General of Central Excise Religions. What is the function they will perform? All this subsection. In fact, section 28 is for issue of show cause notice. See that?
Yes.
Such an assignment ought to have been done under GST as well, which they have not done.
Yes.
Then at page 7, there is another notification of Customs. Just to conclude this. Where has that? Notification number 44 of 2011. Page 7.
Yes.
In exercise of powers conferred under 2 sub 34 of the Customs Act, the Central Board of Excise and Customs hereby assigns the functions of proper officer to the following officers mentioned in column 2 of table for purpose of section 17, 18, 28, 28, AA, etc., etc. of the Customs Act, namely serial number 1, Additional Director General, Additional Director, Joint Director, Director of the Revenue Intelligence, and 3, Additional Director General, Additional Director, Joint Director, Deputy Director, Assistant Director, and Director General of Central Excise Intelligence. They ought to have done something similar. The central government, instead of that, they have the power to appoint, they have arrogated themselves the power to vest as well, which they could not have done. That's the submission that I had. With that, my lord, I
noted that earlier, vesting and appointment.
Yes. With that, my lord, I conclude my rebuttal submission. And I'm grateful to my lord for indulging me.
Yes, I don't think we've heard a case for so long. Anyway, yes, Dr. Mozika and.
Mr. Sinkan, he wants to reply. For me, also, I'll give submit.
We will hear your replies.
Yeah.
Most importantly, on the aspect of alternate
Yes.
remedy. Yes. So when should we keep it?
25th. 25th.
Yes, I'm in Gujarat. I got the day.
They'll be in puja mode.
Look, they can start. I'll join by VC. That's not a privilege. I don't
25th.
want 25th. Let them put. Yeah.
Yes, list for the hearing on 25th.
But in the meantime, should you start preparing a written submission so that?
Yes, please. And just try to make it as concise as possible.
Yes, I will make it very, because I've given the contours of all of that.
Contours are there in your ground. I mean, that's it. Yes.
Yeah, see, that.
I think 16, right? We're doing person time. I think 16, we are writing 10.
I can move it to hotel.
Item number 2.
Obliged.
Item number 2.
How long will it take to one?
A little bit of time it will take, my lord, because I have to take your lordships through the documents, and I,
I
believe
don't
in the
think, because we have to, the bench has to break also. The other matter took a little.
I understand. Would your lordships then take it in some other day?
Yes.
It will not be possible today. Time is very short.
Yeah, possible because we have to break also. We have
I see.
other benches to attend.
I'll take a little bit of time because some documents will have to be also.
We understand, yes.
Yes.
So you take a date.
Whatever is convenient to your lordship.
You fix up, yes. We are here, but only thing is that here give you some time.
Yes,
Okay,
ma'am.
because the other matter with concluding arguments, so we have to.
Right.
Yes.
I'll take a date, my lord. Extremely good. There's an interim order which will. There's an interim order which will.
Interim order. Yes.
Any mention? Any mention?
Please, Lordship, I beg to mention item number 22.
20.
22. That will be taken after 2 weeks.
No objection, Lordship.
Twenty-two.
22 what? BSF?
Yes, yes, sir.
It's a land acquisition appeal.
Yes.
It's 2 weeks. Yes.
2 weeks, sir.
My lord, I beg to mention item number 20, my lord, on behalf of the respondent state.
No objection.
Yes. On the request of also, it's after 2 weeks. Yes.
May it please, Your Lordship. Your
Yes.
Lordship, I beg to mention item number 21, Your Lordship.
Those other side?
From
Yeah,
DCC, we have noticed.
Yes, on the request also after 2 weeks.
Highly obliged. May it please, Your Lordship. Your Lordship, I beg to mention item number 18, Your Lordship.
Number?
18, 1-8.
8.
Yes, Your Lordship.
May I please, Your Lordship, should kindly
Hello,
give
praying
us a short date, Your Lordship.
1 week time, Your Lordship.
Short date means tomorrow.
Not
No, Your
tomorrow, because
Lordship, the conducting
my
council,
senior,
Mr.
London
Sen,
Senior Council
is
is
not keeping well, Your Lordship.
Who, Mr. Sen?
Yes, Your
Sen.
Lordship.
next day.
After 1 week?
Yes,
1 week, Your Lordship.
Yes, okay. On the request also.
much
after
obliged.
1 week. Okay, respondent number? Your respondent number?
Number 2, Your Lordship.
No, Nehu?
3, Your Lordship.
Much obliged.
Your Lordship, similar prayer for item number 24.
Yes. 24.
Objection.
Yes. On request also just after 2 weeks. As the arguing counsel stated to be not well. Yes.
Highly obliged, Your Lordship.
May it please, Your Lordship. Your Lordship, I beg to mention item number 19. The conducting counsel, Ms. N.G. Shilla, is not available today, Your Lordship.
You're there?
Your Lordship, on behalf of Mr. Armaja.
No objection?
No objection, Your Lordship.
Yes. Yes.
Much obliged, Lordship.
Obliged, Your Lordship.
Supplementary list?
Lordship, I beg to mention item number 17.
You're mentioning to her, you wanted to mention to court.
I was just confirming if the other side has been informed.
Item number?
17. The conducting counsel, Mr. R. Gurung, has some personal difficulties. Mr. R. Gurung.
Okay. Yes. Yes, fine.
Grateful, my lords.
Supplementary list item number 1.
What is this?
Actually, Milord, here, Milord, in this matter, Mr. Kostov is there for the caveator.
For R3, Your Lordship. Respondent 3. We
so-
have some difficulty to do that.
Milord,
We can be discharged. We're not going to pass it. We need to ask him for interim orders, are you? No?
my interim order is there, Milord. Milord, I only have one sub. I'll just give a little background of the matter, Milord. Then Your Lordship may accordingly decide. Milord, what has happened, Milord? This pertains to this.
Yes.
Milord, acquisition of land for compensating the land which was taken from the army, Milord, for the expansion of the airport. So 32 acres of land was taken from the army for expansion of the airport, and thereafter, Milord, under directions of this Honorable High Court, the acquisition was done for compensating this land to the army. So this arises out of that, Milord. So what happened, Milord, as per the directions of this Honorable High Court, advance possession was taken with payment of 80% of the compensation, as is permitted under the law.
Yes.
So 80% was given and the land was taken over. So thereafter, Milord, some of the occupants of the land, they were aggrieved. they claim to be tenants, and they went to the Supreme Court against particular orders of this Honorable High Court, that they have not got any compensation. So thereafter the Supreme Court gave a direction to the Honorable Chief Justice here to have an inquiry done by a district judge.
It was a long process that happened with the inquiry for district judge, then came, then allegations of defalcation and
all that.
That is the entire.
That is the matter.
Involved here also, no. Here, what we concerned with?
Here, Milord, that is the main thing. Milord,
that is the background.
No, what happened, Milord? After the inquiry, first an inquiry was conducted by the then first district judge. That was sent to the Honorable High Court. That was not accepted. Sent back for a fresh inquiry by the current district judge at Nongpo. So the Nongpo district judge conducted the inquiry and in 2023 filed the report. Now, that report, all the parties were given options to respond to that. All the responses were done. And then when the matter came up before this division bench,
yes,
in the first part of this year, sometime in February, I think, then what happened, the Honorable Division Bench, with the Chief Justice leading, was pleased to direct that the report of the Nongpo Court, and together with all the records, be forwarded to the District Judge Shillong. And that report of Nongpo Court be treated as an inquiry report only, and now fresh proceedings be taken up before the District Judge at Nongpo in her capacity as the Special Judicial Officer under the LA Act. No, that was in Shillong. Because probably because Nongpo Court had already conducted the inquiry, so the matter was sent before Shillong. Now, Shillong judge conducted the inquiry and submitted her report this year only, some time ago. And then the Honorable Division Bench was pleased to order that this be treated as a final judgment and decree, or that is a final order of the court below, and the parties are at liberty to assail that as per law, under whatever.
Before whom?
Whatever is permitted under the law.
Okay.
Whatever is permitted under the law. So I have come against that under 227.
So this is against an order of inquiry?
No, it is an order of the. In the old act, the term used was Special Judicial Officer, and in the current act, the term used is an authority, rehabilitation authority. Same as Special Judicial Officer. So it is an order of the Special Judicial Officer. So I have come.
Where they awarded amounts? Not
awarded. My whole the Special Judicial Officer has referred it back to the DC.
By this order.
By this order. Now, my lord.
Agree then if it's going to go for a new, inquiry, for a new assessment?
Because the requirements of law is that the Special Judicial Officer is to make an award.
Yes.
Is to make an award. The Special Judicial Officer did not make an award, according to us.
So you come to 227.
Under 227. Now, my lord, I gave it very briefly. Otherwise, I would have taken your lordship through all the orders. Here the problem is that, my lord, the matter when it was referred back, when it came up for the last time before the Honorable Division Bench here, then the order says that the aggrieved parties are free to assail it, and if no order is forthcoming from any appropriate authority, then the government is free to release the remaining 20%. So that brings in the urgency. Because
so you're not in the picture for a 20%.
We're not in the picture.
Who's the picture of 20%?
Well, the thing is that as per the order of the Honorable District Judge Shillong, District Judge Shillong has found no one entitled. No one entitled, and has directed the Deputy Commissioner to ascertain it afresh. But the Honorable Division Bench here said that if anybody is aggrieved by that, then can go to and if no order is forthcoming from any other judicial forum, then that 20%. In my, I'll just take.
See the operative part of where the division bench last order where it says that.
Division, huh? 205. Look, page 205. It's a short order.
Who is the caveator?
I'm the caveator, the beneficiary, Your Lordship.
You already.
Lordship, so far as this order is concerned, page 204, one of the parties have assailed this before the Supreme Court, Lordship.
That's the same order.
This order, 204.
We have not assailed this, my lord.
One of the parties.
204 means?
This page 204,
Lordship.
Oh, sorry.
And the respondent number.
Yes, it is there before. One of the other. There are three claimants, my lord.
Respondent number
2
4.
of us and another claimant is there.
Yes. Yes.
Now, respondent number 4 has gone to Supreme Court, the Honorable Supreme Court, to challenge this order, Lordship. Page
Number 4 is.
She is also one of the claimants, Lordship.
Number 4 in this is.
No, in the present petition.
Here?
In the present petition. Respondent number 4.
That is State Dakar.
State Dakar.
State Dakar. So, my lord, I'll just. Shall I take your lordship through the.
No, it's fine. What we'll do today.
Only the last order, my lord, last part of your lordship.
Of that order is.
My lord, last part, 207, my lord.
Yes.
Page 207. We only clarify. My lord, just a paragraph before that, my lord. In those circumstances, we treat the judgment and order dated 20th June 2025 as the final judgment decree made by the learned special judicial officer in the exercise of her original jurisdiction. Any party aggrieved by the judgment decree or any part of it shall be at liberty to take steps in accordance with law. So that is how I have come before your lordship now. We only clarify and direct that 20% of the compensation amount which is withheld by the state will continue to be withheld for a period of 8 weeks from the date after which it shall be released to the said transferor if there is no order to the contrary. The period between 20th June 25 and pronouncement of this order shall be excluded in calculating the period of limitation for any appeal or application or other proceedings. So, this 20%, release of this 20%, if that is not done, the matter can be taken up at convenience. There's no problem in that, So, I would only submit, if till the matter is taken up, if the 20% is not released.
I don't think release in a hurry. Yes.
Some sort of an undertaking. Some sort of an undertaking.
And this order is assailed before the Honorable Supreme Court.
I mean, this is your lordship. Lordship, only I would like to raise the maintainability of this
227 application.
Lordship, yes.
So that you'll have.
That's of course.
That is yes. Your respondent number 3.
For 3.
So seen the caveat application. Seen the caveat application. Caveat represented by Mr. M.L. Nongpur.
I'm being led by Mr. K. Paul.
Being led by Mr. So-and-so, senior advocate. It is seen that the caveators are read as respondent number 3 in the civil revision application. Accordingly, caveat stands discharged. Is in the main case, heard Mr. Esther Golti, senior counsel, assisted by so-and-so. You should notice. Mr.
I for 1 and 2, your lordship.
1 and?
1 and 2, your lordship.
Mr. Andy Schreiler, EAG with so-and-so is present on behalf of 1 and 2, and Ms. Emily Nopio is present on behalf of the caveator. Respondent number 3. No further notice on these respondents. Stop notice to issue to the respondent number 4 within 3 days. Why? Yes, just after 2 weeks for the orders. The prayer for interim orders shall be taken up the next date.
If in the meantime some protection is given, after 2 weeks, this date will go, only submission is, till that matter comes up, if the remaining amount is not disbursed.
Actually, we're challenging the
maintainability
as well.
On the next day, maintainability and everything can be taken up.
Fixed for admission
Once
hearing.
one interim order is given, it will continue. That's the only thing.
Let it come for admission hearing, Lord.
Come for admission hearing
after
1 week.
Lord.
You will not do anything, just as you give undertaking, Mr. Shulai. No step taken by the government to release any amounts. for the next day. We will not record it, but it's a personal taking that you we'll hold you accountable if anything happens. Yes.
Item number 2.
Just an observation, just an observation, Milord.
No, he can't give the concession also, but we'll hold him accountable. Don't worry. Nothing that cannot be undone.
Obliged.
Item number 2.
This matter pertains to pension of the MDCs of the Garo Hills Autonomous District Council, my lord.
But it's become a very sad story, Garo Hills Autonomous Council.
Yes, my lord.
You're part of the agitation, no?
No, my lord, we are the ex-MDCs, my lord.
Oh.
We are not employees. We are not employees.
You take notice, Mr.
Yes, at this stage.
No, my lord, I have an objection.
To take notice?
Yes, my lord.
Why?
Whether the petition is maintainable. In 2 grounds, my lord, I will...
That will...
No, my lord has to decide today. Whether why, my lord, I'm saying is this.
Elections are coming.
No, not that, my lord. If my lord kindly give me a chance, I will place my case. Why I'm saying it is not maintainable, my lord, and judicial note cannot be taken. An association is before this honorable court. And the claim is that an association is before this honorable court. Now, whether the association is a registered body or not. If my lord may kindly see the annexure 1.
It's not registered.
It is a defunct body.
It's not defunct, my lord.
It's a defunct body, and my lord may kindly see. They have applied for, my lord, and I have taken out from the website yesterday, my lord, that it is under process. That means today, my lord, on the day of filing the writ petition, is not registered, my lord. And when the matter has been heard, it is not registered. My lord may kindly see. One Mr. who has applied, my lord, this is on date 10/9/2025 at 5:53 p.m. I have taken out this note, my lord. Applied by Chesarang K. Sangma. We don't know who is that person. Now, my lord may kindly see
page 42 is
number 3, my lord.
Certificate.
Serial number 3 under process. Now, my lord may kindly see the annexure 1 by which they are claiming they are registered, which is a defunct body, my lord. They have not enclosed anything to show that today the register is the body is registered. My lord may kindly see page 42, my lord.
Yes.
Page 42 says, my lord, that they had registered, and it was in January 2009, my lord. Thereafter, no document has been placed before this honorable court on record, my lord.
But one thing, is it the fact that they're not being paid the pensions?
That, my lord, I have to take instruction, my lord, whether they have paid or not. But the fact is this, one more glimpse of my argument is this, my lord. Whether, my lord, this is a service matter or not. My friend has made a submission in code number 4, my lord, that this is not a service matter. That is why this has been placed before this honorable court. But my lord may kindly see, I have checked, my lord, code and category, which my friend has filed, my lord. It is under other service, my lord. My lord may kindly see the High Court rules, my lord.
Yes.
High Court rules says, my lord.
So you have very technical objections.
Yes, I have the technical objections.
No factual objections.
That I need to take instruction, my lord. If my lord may kindly peruse this, my lord.
So according to you, will come under what category?
That I don't know, my lord. It is for my friend to decide, my lord. How can I decide his petition, my lord? My lord may kindly see page 3, my lord.
Yes, yes.
Of the code and category. Page 2, my lord, I will just read the head note. Writ petition relating to service in local bodies, banks, states and central public sector undertakings, statutory bodies and university and institution. Now we are an statutory body, my lord. My lord may kindly just see the last on page 3, my lord. CR, the code and category which my friend has come, 10059. Sorry, my lord, it is 10060, other service matter. If it is that service matter, my lord, it has to go to code number 4, my lord.
Anyway, the roster is changing next week.
That may be, my lord, but at present, my lord,
Anyway,
this is the submission.
We note your technical objections and we will deal according to the admission. Yes, sir. Mr. Nongri, Council of Petitioner issue notice. Mr. SD with Mr. Andy Shulai Leonard AAG with so and so is present, except on behalf of respondents.
If I lord, because the
3, 1 and MS EB Prasad.
Because this matter, my lord, has been decided by this honorable court
yes,
only.
You bring that. Let's do admission hearing. You be free,
my lord. Then let it come next week, my lord.
Yes,
let it come up Monday, my lord.
Mr. S. Day present and except we have 1-5. No further is called for stop. When the matter is moved, Mr. S. Day has made some technical objections as to the petitioner being unregistered body and also the category under which the institute application has been filed. So, be as it may, the respondents are liberty to raise or have objections, and the next date, this matter of addition hearing after 10 days.
My
10 days will be now the
September, my lord.
no, September, yes.
11th. Let it be on 19th, my lord.
No, 19th the court won't be there.
It will be on 23rd, Your Lordship.
23rd.
No, not Tuesday, 22nd.
22nd.
Lordship. Highly obliged.
Item number 3.
Yes.
Please, Your Lordship. Should we kindly come to page 82?
What's the matter about?
This matter pertains to the removal of the acting link law, Lordship, of the Palyar clan.
Acting law?
Yes, Lord.
What rights an acting law have?
Can you come to page 82?
You have separate act, no, what's support? If you have
No,
separate act,
no.
It's still under 59.
Under 59.
Yes.
Lordship, to respondent number 5, he was removed as the acting link law because there's some complaints against him. Now this
Number
order was...
5, you was acting law also.
I'm the present acting link law.
No.
Both are
Number
acting
5 was
link law.
acting also.
Yes.
Then?
Now, page 82, Lordship, the respondent number...
5 Berlin Palyar.
He was the
That's
then...
represented by Mr. Coach.
Mr. Coach.
You ready with the matter?
Yes, sir.
Very good, yes.
So, Lordship, he was removed by this order dated 2 August 2025 because
Yes.
certain complaints against him.
This is that respondent number 5.
Respondent 5.
Yes.
Then at page 84, Lordship. Page 84 was appointed.
Your appointment.
Yes.
Yes.
Now, after that, Your Lordship, at page 92. Since I have been appointed, apprehension that they may challenge my appointment letter, Lordship. So I filed my caveat before the EC. Now there's a receipt by them on the bottom of the page.
Okay, yes.
Now, Lordship, can you come to the impugn order at page 9?
9?
Page 100. Page 100 is the impugn order. Now, against the removal, Lordship, he had filed a complaint. Can you see this subject, Lordship? Complaint.
Respondent number 5.
Respondent 5 has filed a complaint before the Executive Committee. Now, the subject says complaint against the order dated 2/8/2025. With reference to the subject title above, the Executive Committee has received a complaint petition dated 12/8/2025 from Sheikh Hebel and Palyar against the suspension by acting CM. So, on perusal of the complaint along with the relevant documents submitted, Executive Committee is not satisfied with the suspension order number so and so issued by the acting CM. Number supports CMship as the same violates the law of natural justice. Therefore, the Executive Committee KHDC is hereby pleased to state the operation of the order dated 2nd August 2025 with immediate effect until further order pending final decision on Political Appeal 1 of 2024. Now, this Political 1 2024 pertains to the appeal filed by the full-fledged Lingdo who was removed from the post. He had filed this political appeal. Now, they had linked this political appeal with the present matter. Now, without even having received the caveat petition, Lordship, no opportunity of hearing was
One
granted.
thing, Mr. Nompur, your status is an acting link law, correct?
Correct,
And the other removals was acting link law.
Lordship.
Acting law can be removed and replaced.
Lordship, but there's a complaint against him.
A
At least
complaint against him, but he has
the
come
district
to-
council should
the thing
conduct
is
a
that,
inquiry, Lordship.
Against suspension, he filed this number 5 filed a complaint against the removed acting CM, correct?
Yes.
And because he filed against acting CM, you removed him as acting link law.
Yes, and then I had convened Dorbars also of the court, Lordship, on 2 occasions.
Yes, Mr.
I had functioned. Now I'm saying that the district council should have conducted an inquiry into the matter.
What inquiry?
Not jump into passing
You
this.
can just pick up a man from the road and make him acting. There's no hard and fast rule that he has to be from certain clan or if
Lordship,
he
since there's a
governed by
complaint,
59 Act, yes.
Since there's a complaint, at least the district council should look into the matter.
Send it back.
Send it back, Lordship. My prayer is that let the district council decide the entire matter.
Please let them have the, satisfaction.
My lord will come to page 82. That is the order passed by them. It would appear that the person has been removed from the post, not even suspended. It will also come to 82. Yes.
Acting.
No,
1 second, Mr. Coach. We will hear you.
Page 82.
82, my lord. Respected sir, with reference to the subject cited above, this office, the office undersigned below has decided to remove you from the post of acting link law. That's when the district council acted. They said even if you removed him, you should have heard him.
What rights, what versus rights the acting have? You know, what rights does he have? What rights the acting have?
No, but because this is
The
not
acting CM has no
but
rights.
this is
You
not a
he can be
removal.
replaced tomorrow by someone else.
No, my lord, but this is not a removal.
But then
Simpliciter.
the court co-issue, if what I understand, is that political appeal number 1, where the full-fledged CM was
Yes,
removed.
that is
That is the one that needs adjudication. These removal, these people coming here and there,
Yes, Lord.
will have should not have any effect on the,
In fact, the acting CM only should not have acted at all. That's when that's why the acting Lingdo. That's why all this.
I should let the matter be remanded back.
Yes,
Let the
Mr.
district
Coach.
council take up
What is your submission?
entire matter. Lord.
Your Lordship, you agreed by this order of removal.
Please come. I can't see you behind the camera. Yes. From there, fine. Yes.
Yes, Lordship. We agreed by this order of removal by the acting CM from the post, myself from the post of acting Lindo. I filed a complaint, Your Lordship, before the executive committee. And after examining my complaint, executive committee has passed this order, Your Lordship.
Yes, where they've set aside.
And with regard to the caveat, my friend has said about the caveat is not applicable in the investigative, Your Lordship.
See, now that is caveat can be a CPC, but then isn't the nature of caveat. That's all. That is
Another aspect, my lord, is that even this the acting Lindo has filed a caveat before the council also. The person who has passed the order, it shows the collusion.
I am the acting Lindo. Order is in my favor.
Allegations here is that the district council in collusion with 5 has passed this order.
Okay.
Now he himself has.
Yes, the red petitioner, who stated to be an acting Lindo of
Palyar Maukarda like and Thai.
You got it. Palyar Maukarda
like and Thai
of Nobo Support Simship. Is before this court assailing the reinstatement. It'll be reinstatement, correct?
It will amount to reinstatement.
Assailing an order whereby the respondent number 5, who was the earlier acting Lindo, no, I understand. I'll change it. Yes. Number 4, no? This one, no. Complaining against the action of the. That is respondent number, Council.
Joint secretaries.
That is respondent number 1, 2, 3. Number 1, 2, and 3, whereby without affording opportunity of hearing to the writ petitioner, this impugn orders, page
100,
had by order dated 2nd September 2025 had stayed an order dated 2nd August 2025, which had been passed by. What was the order second?
Page 82, Lordship.
Which have been passed by the acting CM Hima Novosopo, wherein the respondent 5 had been removed from the post of acting CM. So, Mr. M. Nongpur, learned counsel for the petitioner, has submitted that the district council respondents by the impugn order dated since September 2025, in spite of a caveat being lodged, had proceeded to pass the order on the ground that the same was in violation of the law of natural justice. Stop. He submits that even the fact that he was not given opportunity to watch proceed of hearing, though he was occupying the office of acting CM, also has resulted in the deprivation of his valuable rights. He therefore prays that these order be set aside or the matter be remanded back for fresh consideration by the council respondents. The parameters deemed the council with so and so has submitted that what is submission?
Caveat is not applicable in
Has submitted that the filing of caveat will be of no consequence as like
it's not a civil court.
In as much as the provision for caveats only applicable to matters before civil courts. He also does not seriously object to the suggestion made by the council petitioner that the matter be examined afresh by the district council respondents by affording opportunity to the writ petitioner. Like Ms. L. Coach, learned counsel for the respondent number 5 who was in a caveat, has also endorsed submissions made by the Senate Council and submits that his removal by the acting CM was also without being afforded any option of hearing.
It was done without hearing.
It's not hearing. Like on hearing, let council parties the examination of the matter. It is seen that the instant issue before this court is only with regard to the office of acting lingdo. It is further seen from submissions and the materials have been placed that the main controversy lies in the which is a political appeal number
1 of 24.
Lies in political appeal number 1 of 2024, which concerns the removal of the full-fledged CM.
Lingdo.
Full-fledged lingdo as
Lingdo.
Full-fledged lingdo.
Which, my lord, is under inquiry by the magistrate.
We will not say anything which is full-fledged lingdo, and whatever has emerged from the said dispute has resulted in the present controversies. It is viewed the matter therefore without detaining the matter any further before this court. All been served.
No, Lordship.
And without and dispensing the necessity of issues of notice on the remaining respondents 6 and 7.
Even 4, Lordship. 4 is the CM.
4, 6, and 7. So this court deems it fit and proper to remand back the matter to the respondent number 2, who shall take a considered decision after affording opportunity to all the parties concerned. As the parties are present in court today, they are put to notice to put in their written submissions before the committee by when.
Two weeks, Lordship.
Within a period. Give an exact date.
Yes, give a date.
Put notice to appear and to file written submissions.
It's 11.
Or we just want to appear. First appear, then let them pass orders. Put notice to appear before the executive committee on
26.
On 26 September 2025. The executive committee thereafter shall dispose of the matter in accordance with law. Will let till this
status quo may be
further orders up,
Status quo should be maintained.
Till further orders are passed by the executive committee, the status quo shall be maintained
by the parties
as on today. Matter stands according to disposal of. According to matter stands closed and disposal.
Item number 4.
Ordered above from the matter stands disposed. Yes. Where's the cross appellant? You're the cross appellant.
Yeah, well, this is my appeal now.
The other matters coming on?
When is it coming up, Mr. Sen? You're there.
This is not a cross appeal, Manoj. This is a regular first appeal.
Oh, the regular first
Not
appeal.
a cross appeal in my appeal.
It's not a cross appeal in his appeal.
No, it's an independent appeal that they filed with
What
regard to the
other
same
claim?
It's a
order.
cross appeal. They have also filed
Other
against that order.
claims.
They have also filed appeal. We are also filing appeal against the same order.
When's the matter listed?
16th
I
of
don't
September.
have the date, but 16th, I believe.
Yes, as a
That's cross appeal.
regular first appeal also pending against the same order dated.
9/6/25.
I heard Dr. N. Mozika, Leonard PSGI, along with so and so. Issue notice, Mr. S. N. is present. You're the only sole respondent.
My lord. So the thing is, I'm not instructed to appear in this matter.
Doesn't matter. Ms. S. N. who is appearing in another matter against the same. Another appeal.
Same order.
His preferred same orders present in court and is directed to accept notice. Is the matter together with FA number.
In that case, a copy may be served, my lord.
FA number.
That is FA number.
We will give.
FA number is also on the next date. Yes. Yes.
6/25. FA 6/25.
Congratulations.
Daily list item number 1.
But the witnesses here, my lord. The witnesses present. Only the first witness, my lord, the
How many witnesses are
petitioner. There are 3 witnesses, my lord. 3 witnesses. 2 are the witnesses to the will and the executors here. My lord.
Both of them, all the 3 are here.
My lord, I'm told only two are here, my lord. The main witness, my lord, number 1, and one of the witnesses to the will is here, my lord.
Have we filed the evidence and affidavit?
Yes, my lord.
It's on record.
On record, my lord.
When was it filed?
But this was filed
Yes.
sometime in July, my
This is
lord.
Bhagishri Deb, and this is number 1 is your
Shekhar Das, my lord.
Shekhar Das. That means you are number 3 here. Yeah. Yes.
Shekhar Das, and then Bhagyashri.
When's the other witness coming?
My lord, the last witness is, my lord, in Mumbai.
Because they have to prove this, the affidavit.
Yes, my lord. The original documents.
They have to be sworn in.
Yes,
they
my
have
lord.
they have to prove their, they have to prove the signatures.
Yes, my lord.
And it's marked exhibits and it'll go on record. But then we'll see. You come at 2:15.
2:15, my lord.
Yes.
My lord.
Yes.
Item number 2.
Sure, I've taken steps on the respondent number 2. I may be allowed to file a service report just to verify.
Yes, you're appearing for him also. No.
I'm not. For respondent number 1, the police station, Lordship.
Mr. Emerald will submit the steps have been taken for number 2. The police force is allowed to obtain status of service on the same. Return answer. Again.
That's only the permanent address, Lordship. The
I've taken steps on 2 address, Lordship.
Okay.
the present address
The present address.
is being weighted.
Okay, so yes. List after 2 weeks.
Congratulations.
Yes. Hello. We record your appearances.
Item number 3.
Yes, Lordship. I required to be filed a rejoinder, Your Lordship. I have received the affidavit.
Yes, 2 weeks as paid, allowed rejoinder.
Lordship. Most blessed, Lordship.
Item number 4.
May please, Your Lordship. Your Lordship, I'm appearing on behalf of Ms. F. Kars Imyong, Your Lordship. She's not available today for respondent 9 and 10, Your Lordship.
We will close the affidavit from 9 and 10.
Your Lordship,
You've taken enough time here.
I was requested to seek for some time, Your Lordship, for affidavit on her behalf, Your Lordship. Lordship, let a
How many
last,
times has
last
we
opportunity
taken?
be given, Your Lordship.
15 times.
No, Your Lordship, let a last opportunity be given. This affidavit's necessary, Your Lordship.
Today, on behalf of MSF Kharsim Myong, has renewed a prayer for time to file affidavit. It is noted that repeated prayers have been made for affidavit. However, in the interest of justice, the Honorable Intendant are allowed last portion to file affidavit. Yes. You already filed it. Yes, Lordship. 6 record your opinion.
Much obliged, Lordship.
Item number 5.
Affidavit file. Where's Dr. Murray?
Please, Your Lordship.
Yes. How much more?
Well, 2 weeks. I have
It's a
received
fresh
it.
matter. Dr. Embassy submits in person have been received. List of a 2 week affidavit.
6.
Lordship, this matter has been referred to Lok Adalat, Your Lordship. So let it's come.
13.
Yes.
Yes, it's reported that the matter has been referred to the National Lok Adat to be conducted on 13 September. List thereafter.
6 and 8 both. The 2 matter.
7.
It's a
6
matter.
These are pay regarding pay and other things. 6 and 8 both.
No, only number 6.
7.
Yes.
The respondents have filed the affidavit, Your Lordship, and bring time for rejoinder.
Who are you appearing for?
1, 2, 3.
1, 2, 3. And Mr. Jarwa?
Filing.
You already filed.
We won't be filing.
You're for whom?
Same of million.
Mr. Sankan for state.
No, my lord, 5 to 8. Limecraft, Dorbar, and Edmund.
You file affidavit.
File one.
You file rejoinder.
Yes, Your Lordship.
It's a percentage please for allowed 2 weeks time for rejoinder affidavit filed by the respondent's number 5 to 8.
5 to 8 and 1 to 3, Your Lordship.
And 1,
1 to 3 and 5 to 8.
Obliged, please.
8.
I'm paying some more time. It's a fresh matter.
3 weeks. That's prayed allowed for affidavit. Yes.
9.
Please, Your Lordship. We are yet to file the affidavit, my lord.
I'm praying for some time, Your Lordship.
For some time.
2 weeks, Your Lordship.
What report voluminous? Where is that? A report, last order, report pretty today, but let's senior. Who's senior appearing here?
NG Shila, Your Lordship.
Shila was appearing, my lord.
Now, where's the affidavit? You're only supposed to bring that report by way of affidavit.
Lordship. I'm praying for 2 weeks.
Why 2 weeks time? Your report only in hand, correct?
Lordship.
Who's the concerned official to sign the affidavit?
The SP, Your Lordship.
SP of West Garo Hills?
Yes, Your Lordship.
No, not Garo Hills, my lord.
Not Garo Hills.
Not Garo Hills, West, South, East. We give you Mr. A.M. Pala today prays that we'll have further time to file an affidavit. File an affidavit. Sub. Prays allowed this up to 2 weeks. You file it.
Hello, my lord.
10.
That's not what
Your Lordship, we have filed our affidavit in items number 10 to 15. A common affidavit has been filed, Your Lordship.
Lord,
We will record the OM dated 9/7/2025.
No, but
Lord, for the
my friend
convenience of
had
Your Lordship.
wanted to submit a chart.
Yes, my Lord. I prepared a chart.
But then the chart has, a copy of the chart has not been given to us.
I'm-
Unless we can see that, how can we agree to the disposal,
Okay,
Your
yes,
Lordship? So, Your Lordship,
MS.T. Yangi B. Then EAG's. What is submission?
my
It's
submission
that
affidavit
will
has
cover-
been filed
that
a
will
common
That will cover all the.
from
Will cover the
10 to 16, you know.
connected matters has already been filed. Stop. Mr. Philam Nongri submitted that has retreated his submissions made in the last date that with the issuance of notification dated 9 July 2025, the matter can be resolved and disposed of. Stop. He has the council has also submitted a chart to assist the court in this regard. Stop.
A copy of which has been
a copy of the chart is also made over to the respondents. Accordingly, this is matter next week.
Yes.
Yes, for further orders. Next week. Where's
Supplementary list.
Shongwan?
Hearing 5.
Have you made that chart? Where's Mr. Sen?
I have.
What are applicable?
Just the first page and the second page is relevant.
Applicable. Those are applicable.
That rule, 1A, which stood amended. I've finally figured out what this possibly means. Kindly turn to page 2, my lord. That diagram at the bottom.
The diagram.
Yes, my lord.
Regulated zone, water body, setback, water body.
Right. So I'll just explain, my lords. The blue one is the water body.
Yes.
So whatever the width may be as per the siting norms. So it depends on what the width of this water body, that will decide what should be the width of the water body setback.
Okay.
Now, beyond that is the regulated zone. So in the water body setback, there can be no new construction. However, in the regulated zone, construction is permitted subject to the siting norms. Now, we were concerned, my lords, with the expression which is at para 5, just on top of it.
Yes.
Para 4, my lord. It says width of regulated zone. If lordships have it, width of regulated zone for a water body shall be 4 times the width of the water body setback. Now, the reason is this, my lord, what I understand, the siting norms prescribe the extent of what the water body setback should be. For example, if your lordships look at the Wards Lake, let's say the width of the Wards Lake is 10 meters. Now, where the water body ends, that is where the water body setback begins.
Okay.
And now, let's say as per the siting norms, the water body setback has to be observed as 5 meters.
Half of the
5 meters or 10 meters, whatever it may be, as per the siting norm. So let's say it's 5 meters. Supposing it's 5 meters.
We have different siting norms for different areas.
For different areas. Yes, my lord. So let's say it's 5 meters. So where the water body ends, that's where the water body setback begins. So they maintain 5 meters. Now let's say this 5 meters
you can't
ends
make any
at the
construction there.
You can't make any constructions. Now let's say this 5 meters ends at the district court, so the deputy commissioner's gate. From there, the regulated zone begins. Now, under the original rules, guidelines of 2023, as they stood, they prescribed the starting point of the regulated zone. They did not prescribe the ending point. So the question was, it will start from the DC's gate, but where will it end?
Yes.
It might go all the way to Nongthomai, Jinking, whatever it may be. So in the amended rules, they brought in this particular prescription. This 4 times the size of the water body setback.
Width of body.
So this could have multiple properties.
1 second. Width of regulated zone has to be 4 times the width of the water body setback. So the setback is 5 meters.
This will be 4 into 5, 20. So it's not his plot of land. It's just the regulated zone where these prescriptions will apply.
As per this prescription, where's his land? Was regulated zone?
Yes, in the regulated zone. He's safe.
Okay, let him examine it. We'll have it disposal on Monday. Yes, note on behalf of state respondents clarifying the exact what do you call it? What is this? The exact interpretation of
1A
Meghalaya water bodies bracket conservation and protection those bracket guidelines 2023 has been produced. So as per the note, it appears that the construction of the petitioner will fall within the regulated zone. However, Mr. Shongwan, please will have to examine the same. This is a matter on Monday for disposal. This is very helpful. Actually, because that was a confusion.
Yes, my lord. We were also confused. So this is what I could understand. Perhaps
can we import this into the order? It will help other cases also.
Yes. Lordship. If lordships agree to that interpretation, that's the only thing I can think of.
That's the only thing that can possibly mean only that.
Because they provided a starting point.
They removed with amendment, they removed the lacuna, I mean.
Yes, my lord, yes. In fact, the recitals of the amendment clearly prescribes that the division bench had noted that there were a lot of obvious mistakes in the original guidelines.
Yes. How many hearing matters are there?
At least 2.
Any urgent hearing matters? We will take up hearing today, I think.
23 and 25.
Except for that evidence at 2:15.
23.
Obligement.
Ms. Hassan next week, 23. 25?
25?
Yes. After 2 weeks, Lordship.
25 after 2 weeks. You're agreeable? You're for whom?
Yes, I put a petition.
You're for the respondent? Yes, 2 weeks. 25, 23 next week.
Also after 2 weeks.
Okay. On the prayer council parties, this good. Where's Mr. Sen? You just inform me if he can, if he can give a soft copy of this.
Lordship, will inform.
Just inform that. Just he can just give to the PS on a pen drive soft copy of this. It's very helpful.
Yes, sir. I'll do.
Yes. Right.
Much less, Lordship.